All right, everybody. Welcome to the House Judiciary Committee. It is, I don't know, March 8th, I think, about 2:40, and we're going to get started with a long evening of bills. So we're going to start with Delegate Williams' bill, House Bill 808. I understand the Attorney General is here and is with you. Who else would you like on your panel?
Yes, thank you so much, Mr. Chair.
Oh, I have the numbers written by them. It helps when you read things.
Yes, so on my panel, obviously the Attorney General, as well as Robin Elliott, Pam Kastmeyer, and Lisa Jordan, if there's room. Oh, and Michelle Seary.
Seary, Robin Elliott. Okay. We'll need an extra chair. We're getting that worked out. Delegate Williams, if you will begin for 3 minutes.
Okay, good afternoon, Chair Clippinger, Vice Chair Moon, who's not quite here yet, and members of the House Judiciary Committee, as well as our friends from the Health and Government Operations Committee. I'm Delegate Nicole Williams, representing District 22, and I'm asking for a favorable report on House Bill 808. You will hear from some medical providers about why this bill is needed. You will also hear from someone who's come to Maryland from another state to obtain legally protected health care here. And you'll hear from the Attorney General's office about why this bill is constitutional. This bill does not violate the full faith and credit clause of the U.S. Constitution. This bill does not prevent someone from suing a doctor for malpractice for harm that was done to them as a patient. This bill still allows all of our medical boards, including the Board of Nursing, to engage in disciplinary actions in cases where the health practitioner failed to meet the required standard of care. And folks, people are already coming here to Maryland to seek legally protected health care that they cannot obtain in their home state. This is already occurring, and you will hear testimony to that effect. Per the fiscal note, this bill is simply procedural in nature. The ruling by the United States Supreme Court last year in the Dobbs case has resulted in a patchwork of vastly different abortion care laws across the country. 24 states have already banned or are preparing to ban abortion care. This will result in about 34 million people of reproductive age without full bodily autonomy and access to critical health care in their states. States are using creative legal methods to expand the enforcement of these bans, such as SB 8 in Texas, which has been copied in Oklahoma and in Ohio. These types of legislative attempts by other states not only attempt to control the bodily autonomy of the citizens in these states, but makes it risky for Marylanders to treat or support out-of-state patients. It is having a chilling effect on our medical providers, some of whom wanted to come and testify today but were afraid of doing so. These out-of-state bans do not prevent someone from obtaining abortion care. They simply increase the costs and risk to people who wish to obtain the care that they so desire. And so I want to be clear, abortion care is legally protected health care here in Maryland. Abortion care is legal here in Maryland. This bill says that we are not going to allow our citizens to be harmed for obtaining the health care that they wish or need, or for assisting someone who wishes to obtain legally protected health care. Abortion care is health care, and for those reasons, I am asking this committee to give a favorable report to House Bill 808.
Thank you very much. Just very, very briefly, we do have Delegate Lopez, Delegate Riley, they're behind me. Delegate Lopez and Riley are behind me. Delegate Martinez at the end of the horseshoe there from HGO. Mr. Attorney General, please.
Mr. Chairman and members of the committee, both committees, I'm Attorney General Anthony Brown, and I'm testifying in support of HB 808. This important bill does several things to protect the fundamental right to reproductive freedom that is recognized in Maryland. The bill amends the various provisions of the Courts and Judicial Proceedings and Criminal Procedures articles to resist attempts by those states that have passed anti-abortion laws to criminalize the behavior of patients who are seeking legally protected reproductive care. The bill amends the Health Occupations article to protect the health care providers who offer these reproductive services in Maryland. It prohibits the Health Occupation Board from taking adverse action against the provider because they provided legally protected health care in accordance with Maryland law, even if adverse action is taken against their license in another state. The bill amends the insurance article to prohibit issuers of professional liability insurance from making a healthcare practitioner suffer the effects of providing legally protected health care. An issuer cannot refuse to issue or renew a contract, increase premiums, or change terms, or report the practice of legally protected health care to private or government entities. And it amends the State Personnel and Pensions article to prohibit state and local agencies and the agents and employees of those agencies in their official capacity from assisting in a multi-state investigation or proceeding relating to legally protected health care in Maryland. As the committee is aware, you experienced it this morning on the floor on second reader. The Maryland General Assembly is about to enshrine, or at least send to the voters, a constitutional referendum to enshrine this fundamental protection in the Maryland Constitution. It's vitally important to those who provide or support or access reproductive health care in Maryland that we provide in return the highest possible guardrails for their safety and privacy, or else we have provided a right that is merely theoretical rather than substantive. In wrapping up, Mr. Chairman, I realize the committee may hear suggestions for clarifying content or to correct possible drafting errors in the bill, and my office is ready to work with members and key stakeholders on amendment language in committee or a work group. But in the meantime, I urge the committee to pass this bill with a favorable report. Thank you.
Thank you so much. Good afternoon, Mr. Chair, members of the committee. For the record, my name is Michelle Seary. I'm the Executive Director of the Women's Law Center of Maryland, also here on behalf of MLaw. I want to first thank our sponsor, Delegate Williams, for her leadership on this, and of course the Attorney General, not just for being here today, but also for joining the lawsuit in Maryland that's going to, or across the country, that's going to protect access to mifepristone. So as you've heard, in the wake of the Dobbs case, sending abortion rights back to the states, there has been a concerted effort to attack reproductive health care across the country. You're going to hear from providers today who not only fear for their physical safety, but their ability to also to just provide for their living and continue practicing medicine. You're going to hear from patients about their experiences of what it's really like to try and access abortion care today. And you're going to hear about what we can do in Maryland to prevent the long arm of other states from coming in and intimidating patients and having a chilling effect on our providers. So what we can do is join the 14 other states who have either passed legislation or executive orders that are very similar to the Reproductive Health Protection Act. Now, I know at first glance it might look like a lot of pages, a lot of words, but I assure you, as Delegate Williams pointed out, it is a procedural bill at heart, and it's pretty straightforward. It goes through our criminal, our civil, and our administrative procedures and ensures that they are all consistent in protecting Maryland providers and patients from out-of-state investigations and proceedings related to that legally protected health care. So what does that mean? It means we will not issue foreign subpoenas, summonses, or ex parte orders. We will refuse to extradite Marylanders for acts that occur legally in our state. We will refuse to enforce foreign judgments stemming from punitive laws such as SB 8 in Texas. And it means that we will not penalize providers for through their insurance or their licensure for issues that happen safely and legally in Maryland. I do want to point out that this bill does not apply to conduct that is subject to criminal or civil liability here in Maryland. It does not apply to a claim brought by a patient for their malpractice, and it does not apply to the subject of an investigation who provides written consent. So in sum, our reproductive rights are only as meaningful as the shields that we provide for them, and I urge a favorable report on House Bill 808. Thank you.
Good afternoon, Robin Elliott. I'm here today representing Planned Parenthood of Maryland and very much appreciate the opportunity to speak with you about this bill. I wanted to make just several points. First, this shielding bill, there is nothing new in this shielding bill. The states that protect abortion rights that have been in session since Dobbs was first decided, they all have passed one by one these shielding bills. So what you see in front of us is really taking the best practices we have learned from those other states about how to do this. We have the benefit, sometimes we like to be the first. In this case, I think we have the benefit of learning from others. The second is that I work with Planned Parenthood, but I hear from providers all across our state. They are terrified that what is going to happen, because many of them work in multiple states. We've done a lot in Maryland to really increase reciprocity, increase care. People go to DC, they go to Virginia, they go to Pennsylvania to practice. Their license here is at risk if any of those states, such as West Virginia, that has banned abortion, takes action against them. So what this bill does is it says a physician or a nurse in Maryland who loses their license in a state like West Virginia, we will protect them here as long as that care is legal. Similarly, if their malpractice insurance goes up exponentially because they've lost their license in a place like West Virginia, we will protect them here by making sure that their malpractice insurance stays the same. And I ask for your favorable report and very, very willing to work with the committee. Thank you.
Hi. Yes, Mr. Chairman, members of the committee, I'm Pam Casemeyer, and I'm here on behalf of the State Medical Society, the Academy of Pediatrics, the Mid-Atlantic Association of Community Health Centers, and the College of Obstetricians and Gynecologists. That is a very broad range of our provider community, and I think we're here today to say this shielding law is about those who provide reproductive rights, but it's broader than that. I think you've heard from the previous witnesses the chilling effect that some of the prohibitions in other states have created, even sometimes when you're worried about referral practices. It may not even be what you're doing, but it depends on how other state laws may interpret what you did. So all of these organizations, some of whom historically have not weighed in, are all very concerned about the current legal structure and the ability to practice what is legal in Maryland. And I think you've heard that from everyone today. And I think we want to just keep repeating it. This is only protecting what is already legal in Maryland. It doesn't protect you from malpractice. It doesn't protect you from any other thing that right now, if Dobbs had never been repealed, Maryland couldn't do with respect to a license. It just maintains the current structure as opposed to subjecting it to actions that other states have taken that put our providers in Maryland at risk for the legal services that they are providing. So on behalf of all of these organizations, we'd strongly urge a favorable report.
Mr. Chairman, Mr. Vice Chair, members of the committee, and the members of HGO, I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. Thank you, Delegate Williams, for your leadership. Thank you, Attorney General Brown, for your leadership on this as well. We're here in strong support of House Bill 808. The Maryland Coalition Against Sexual Assault, you've heard me say many times, represents the rape crisis centers. And to state the obvious, we help rape victims. The access to abortion care and information about reproductive options, that's vital for survivors of rape. The CDC reports that almost 3 million women in the U.S. experienced rape-related pregnancy during their lifetime, and a 3-year longitudinal study of rape-related pregnancy in the U.S. found that 5% of rape survivors of reproductive age became pregnant as a result of the rape, with a majority of those pregnancies in adolescence. Of these, half terminated the pregnancy, about 6% placed the child for adoption, and about a third keep the child. Adolescents, I'd note, are more likely to become pregnant as a result of rape because they are less likely to be on birth control or to seek emergency contraception. Survivors of reproductive coercion also need access to abortion care without fear of being prosecuted. Reproductive coercion is a form of intimate partner violence where a woman's partner tries to control reproductive decisions by preventing access to or tampering with birth control, forcing sexual intercourse with the intent of causing pregnancy. And of women who are raped by an intimate partner, 30% of them experienced a form of reproductive coercion by the same partner. House Bill 808 is needed because these survivors need to be able to speak with Rape Crisis Center staff, healthcare providers, and others without risking civil or criminal prosecution. And likewise, Rape Crisis Center staff, healthcare providers, and others should have confidence that they can do their jobs and provide survivors with the full range of reproductive options without fear of out-of-state prosecution, civil suits, or losing their Maryland license to practice their profession. For these reasons, the Maryland Coalition Against Sexual Assault urges the judiciary to report favorably on House Bill 808.
Thank you very much. Just to give everybody else a sense of the rules or a sense of who's going to go next, the next panel, we're going to take questions here, but the next panel will be Ann Seacott, Matthew Dudzik, Michael Tran, Michael Petty. Then there are quite a few people who are on virtually, and I see 4 of them so far, including Ms. Stone, Ms. Anderson, Mr. Spear, Ms. Roche, and Ms. O'Donovan Savada. We'll take them as the third group. So that's what we're going to do from here. We'll start with questions with Delegate Kaufman, then Delegate Grammer.
Okay. Well, thank you, Mr. Chair, and I will be asking fewer questions today. But I wanted to just ask you, Mr. Attorney General, because I'm not a lawyer and you are a Harvard-educated one at that. So my question is, the Catholic Conference asserts that the Delegate Williams' bill, and I have 2 questions if that's okay, Mr. Chair, that Delegate Williams' bill violates the full faith and credit clause of the Constitution. So I'm wondering if you can explain it in a way that the non-lawyers can understand why it does not do what they fear it does. And secondly, I'm going to give you a chance to respond, but the other piece is for Mrs. Casemeyer. In their testimony, the conference states that it will make it, people won't be able to go after their physicians for misconduct, but I did a search of Delegate Williams' bill, and I don't see anything about malpractice, so am I missing something? So we'll start with you, Mr. Attorney General.
Sure. Let me start by saying there are many areas in the law where states differ on criminal procedure, on things like when to accept a foreign judgment, a creditor judgment, and those laws have been challenged for decades, if not centuries, and have survived challenges under the full faith and credit clause. So we are confident in the Office of the Attorney General that we can defend successfully any challenges to the various provisions that you heard, whether it's prohibiting judges from compelling testimony, whether it's prohibiting the enforcement of foreign subpoenas, prohibiting the governor from extraditing someone unless there is a writ of mandamus issued by a federal court. So where we are prohibiting the judiciary or the governor from acting, certainly if a federal court were to intervene, then that's going to trump this legislation. But we're very confident that we would survive a challenge under the full faith and credit clause of the Constitution.
Can you define what a writ of mandamus is, please? Thank you.
Say that again.
Can you define
Sure.
what a writ of mandamus is, please?
Yeah,
Thank you.
it's essentially when a court requires a public official to act or to stop acting. So if the governor of another state went to federal court and was seeking an order that the governor of Maryland extradite someone to that other state, if they were successful, if they prevailed in federal court, then the governor of Maryland would have to abide by that order. We would defend the governor. We would defend him not only in the court of original jurisdiction, but on every appeal, because that's how strongly we feel about providing those protections that are set forth in this bill to safeguard an individual's reproductive freedom rights.
Thank you. And Mrs. Casemeyer, my question about malpractice, because they say you wouldn't be able to go after your physician for misconduct.
Yes, thank you for the question. There is nothing in this bill that limits the right of a patient or anyone to take action, a malpractice action against a provider for services provided in Maryland if they believe there was a case for malpractice. It would go through the same process now as it did before. This only shields actions by the legal structure in another state, not about the patients themselves who receive care here if they believe there was malpractice.
Thank you both very much, and thank you, Mr. Chair, for your indulgence.
Thank you, Mr. Chair. So pretty heavy political winds blowing around here. Everybody kind of wants to just protect what they have. There are institutions in the state who don't provide abortions You know, maybe some hospitals would, some hospitals don't. For example, a Catholic hospital, St. Joe's, they don't do abortions. Would you, you know, you have private women's care providers, they provide gynecological services, they do labor and delivery, they just don't, for whatever reason, they're non-religious, but they just don't do abortions. Would you support an amendment to this bill that protected those institutions, whether they fell under some kind of like the Catholic guidelines of conduct or religious objections, or we just don't do abortions and that's the choice of our organization? Would you support an amendment that protected the ability, frankly, the freedom of association for those people, if the constitutional amendment does pass, to protect their right just to say, you know, we understand you're legally protected, but we just don't do that?
Yeah, I think that what you're proposing, this bill is not the vehicle for that. And so those institutions, they have the right to choose not to provide that health care. That's perfectly their right currently under our state law. And so I don't think that there's a necessity in which to amend the bill to basically rehash or restate something that's already currently in the code. And so I don't think it's a necessity, and I don't think that this bill is the vehicle for that.
I'm not sure that that's true. We heard a bill several days ago from the Attorney General, which would empower him to enforce certain civil rights.
Right,
Now,
and that's for his office, but those institutions would still have their own private rights of action that they could take, and that is still allowed currently under the law.
I don't know if that's true. And let me say, I think the constitutional amendment this legislature has before it, who writes a constitutional amendment says you have a right to an abortion except when the state has an interest in it? Like, I don't understand it at all. But if you write it into the Constitution, I mean, what happened at St. Joe's in regard to gender re-identification surgery, you know, they accepted money. So now you have a Catholic hospital, and it's been ruled that they have to deliver, you know, gender reassignment surgery.
If I could just comment, Mr. Chair, let me just clarify. There's no bill that I presented to this committee either today or in previous sessions that would have required any faith-based institution, hospital to perform an abortion or abortion services, or that would give my office the authority to investigate or enforce the right for someone to reproductive freedoms in that institution. And this bill doesn't do that either. So the issue you raise, and what I think what Delegate Williams is saying is, whether someone agrees with you or not, this is not the bill. This is not the vehicle, because this bill does not impose anything on the institutions that you're describing.
I pray that's not the case. Thank you.
Delegate Conaway.
Thank you, Mr. Chairman. Thank you, delegate and panel, for coming in. To the Attorney General, I just have to ask this question. So the part that says unless compelled by a federal court, generally speaking, if you have another state that's in another district, like in District 4 or District 5, I think, and you're in District 4, your case will not go up to the Supreme Court level because you have to find someone to challenge the case. Isn't that correct?
Well, I would imagine, if I'm following your question, you're sort of working through what would be the venue, what would be the courts that would hear this challenge?
Yes.
Right. I would assume that in state, XYZ, that the governor would bring an action in federal district court in state XYZ. We would certainly defend the governor there. It would go up, I would assume, to the appellate court, the circuit court, the federal circuit court over state XYZ. And whether or not it makes it to the Supreme Court, that's typically when two circuits are having different interpretations of the law. But eventually it could make it to the Supreme Court.
Okay, and just to be clear, in reference to what this bill is talking about, unless compelled by a federal court, because we're talking about shielding or this being an asylum state, there really should be no reason that there should be a challenge. Is that correct?
Well, let me say, Delegate, with some of the things that we're seeing coming out of these anti-abortion states, I don't know what to expect in terms of legal challenges to this bill, to be honest. And as I said, and I'm confident that we can successfully defend not only the provisions of this bill, but any Maryland public official who would be the subject of an action brought as a result of this bill. So we're very confident that we will successfully defend both the bill and the persons who are in the bill.
Thank you for that answer. Thank you very much.
Thank you, delegates, so much for bringing this bill. I have a question. In reading the section that prohibits a judge from honoring an out-of-state criminal subpoena, I just wondered if it would be helpful to have a catch-all language, because I'm worried about, in Maryland, there are state's attorneys subpoenas that can be issued without a grand jury investigation being open, and so I just worry that there might be investigative subpoenas in other states like that wouldn't be captured within this language. So just a suggestion to think about.
Yeah, I mean, we can certainly look at it. I was thinking that we caught all subpoenas that would come in from out of state, as you know, with any, and Michelle Siri can elaborate a little bit more on the process. But, there is a requirement of a hearing that is required to take place whenever a circuit court receives an out-of-state subpoena, and then the court would review that as well as hear from the individuals that are the subject of that subpoena. So I don't know if
Right. So, and I do think we do actually have a catch-all, and that's the provision that's actually in state personnel and pensions, which talks about we are not going to cooperate in any way, provide state funding, state employees, or any state resources in any out-of-state investigations or proceedings.
Okay. I was just looking at, if you think that covers it, that's fine. I was looking at the definition of.
Right, and then the subpoena section, yeah, I got you.
Thank you so much.
Thank you, Chairman. As always, it's a pleasure to have such a distinguished panel. Since abortion is a tool of human traffickers, do we potentially run the risk of increasing human trafficking?
I don't think so, not with this bill.
Delegate, I would just say that you will actually be hearing on one of the panels from the Human Trafficking Prevention Project, and they are adamantly in favor of this legislation.
Right. Thank you very much.
Thank you, Mr. Chair. For the bill sponsor, looking at the testimony, 1199 SEIU had a good suggestion of amending the bill to also protect providers of gender-affirming care. Is that something that would be amenable to be amended to the bill? Because we know how politicized gender-affirming care is right now, and protections are needed for those providers as well.
Yes. Thank you so much for the question. I definitely wholeheartedly agree with you that we also need to protect those who are seeking such care. I know that there's other legislation that's pending around gender-affirming care, and so my hope is that we can address those concerns with that other legislation that's specific with regards to that, but definitely am supportive of the need to definitely protect individuals who are seeking such care.
And just a follow-up. This bill, though, protects the providers, correct, as well as the individuals that are seeking the care?
That is correct.
Do the other bills you speak of also do the same thing?
I'm not 100% certain, but I can look into that.
Thank you.
We won't tell Chair Pena-Melnick that you asked multiple questions. Any further questions? Any further questions? How dare you? Any further questions for this panel? We are the land of many questions. All right, thank you all very much. That concludes the first panel. We'll go to the second panel now. Ann Seacott, Matthew Dudzik, Michael Tran, Michael Patty,
Michael Patty is upstairs.
well, all right. We'll see if he can get down here in a moment. If Mr. Patty still wants to testify, we could take him as part of the next panel, but that's fine. We'll just hear from these three and then questions and then the next panel. All right. Ms. Seacott.
Good afternoon, Mr. Chair, members of the committee. I'm Ann Seacott, testifying today on behalf of the Maryland chapter of the National Association of Social Workers in strong support of the bill. Social workers work with all kinds of people, including people who are pregnant, people who are considering having an abortion, people who have had abortions, people who are victims of sexual assault. They provide counseling, they provide referrals for other services. and they need to be protected as well as the other providers and their patients as well. We need to make sure that they are protected when they do their jobs here in Maryland. Thank you very much.
Good afternoon, Mr. Chair, members of the committee. For the record, Matt Dudzik on behalf of the Board of Physicians here to testify in support of House Bill 808. The Maryland Board of Physicians is the regulatory body charged with protecting Maryland patients by ensuring that all medical care provided in this state is safe and effective. When carrying out this duty, we look at a number of factors, but at the center of all of this is one core question. Did the medical care that the patient received meet the appropriate standard of care? In every such decision, the board attempts to center the patient and the care itself rather than any political considerations. Unfortunately, in some cases, care that is considered safe and appropriate, both here in Maryland and throughout the medical community at large, is restricted or even outlawed in other states. The board's position has always been that reciprocal disciplinary action should always be limited to acts that would constitute a violation under Maryland's Medical Practice Act. But as we increasingly move to regulatory models that prioritize interstate care, the board has grown concerned that we might be used as a hammer to enforce discipline for acts that occurred in other states, but that would be fully permissible here in Maryland. House Bill 808 alleviates these concerns by explicitly stating that we are only to take action here in Maryland if the care provided was not in accordance with the laws of this state. This allows us to once again center the patient in our disciplinary decisions and ensure that our focus is where it belongs, on safeguarding the public by ensuring that all medical acts meet the appropriate standard of care. The board urges a favorable report on House Bill 808, and thank you for your time.
Good afternoon, Mr. Chairman, members of the committee. My name is Michael Tran with the Maryland Board of Physicians. The board would like to thank Delegate Williams for leadership on this bill. My colleague here has offered the position of the board, and I'm just here for Me Too. Thank you.
We like Me Too testimony. All right. Are there questions for this panel? All right. Seeing none, we thank you all very much.
Thank you.
And we'll go to those people who are here set to testify virtually. We'll be looking for, is it Mr. Patty, I think? I think that was right. Mr. Patty, who if he's available, we'll try to get him in here, but only if it's before everybody else. So we're going to hear from Judy Stone, Madison Anderson, Bob Spear, Julia Roche, and Christine O'Donovan Zavada. Let's begin with Judy Stone.
Hi, I'm Dr. Judy Stone, and I live in Cumberland, Maryland. I'm a physician and have practiced for 40 years. I'm testifying today for the Mountain Maryland Alliance for Reproductive Freedom. I strongly believe that healthcare decisions must be between the patient and his or her physician alone, and that these healthcare discussions and decisions must be shielded from disclosure and the threat of disclosure. As an infectious disease doctor, I mostly saw complications from whatever illnesses, including serious infections from a botched abortion. Poor women in Western Maryland have to travel for hours to obtain a safe and protest-free abortion in Baltimore. And this is without any public transportation being available. I'm also aware of women who were forced to carry and deliver fetuses with fatal abnormalities because local hospitals refused to allow late-term termination. I became acutely aware of religious restrictions on reproductive care years ago when Sacred Heart and Memorial Hospitals initially planned to merge. That would have put all health care in Western Maryland under the restrictions of the Catholic Church, prohibiting not only abortions, but vital contraceptives, tubal ligations, HIV, and STD counseling. The clinical research I did on new antibiotics would not have been allowed because volunteers in any research trials must use contraceptives. Healthcare decisions are profoundly personal and demand utmost privacy. They should not be dictated by others, and they certainly should not be influenced by the risk that anyone, patient or physician, could be sued or prosecuted in another state. Being so close to West Virginia, we expect women from out of state to seek legal abortion in Maryland. Those helping them need to have the protections of the shielding bill. Contrary to what our local delegates may tell you, many people in Western Maryland do support having accessible, affordable, and comprehensive reproductive health care locally. I urge you to support HB 808. Thank you.
Ms. Anderson, please.
Mr. Chairman, members of the committee, thank you. For the record, my name is Madison Anderson. I'm 22 and from Houston, Texas. In September of 21, I had come out of a 2-year-long relationship, so I decided September 15th to take a pregnancy test. I remember taking the first one, and the line had developed before the control. I had called my sorority sister to bring me more because I was in disbelief. At one point, I had 5 positive pregnancy tests in front of me. After seeing multiple positive tests, I talked to my sorority sister about my options before me, and I knew that abortion was more than likely the choice I was going to make. I called Planned Parenthood the next day to schedule my first appointment. The nearest clinic was only about 5 minutes away from where I lived. While on the phone with the representative, she explained to me about SB 8, which banned abortion after 6 weeks. The earliest they could bring me in was about a week later. At the moment, I was totally okay with this because I believed that I was only about 12 days along. To my surprise, I measured at 10 and a half weeks. That meant I could not get my abortion in my home state. I called 20 clinics after my first visit. Yes, 20. The earliest I could be seen was 2 weeks later at Jackson Women's Health Organization in Mississippi. The journey that started with a 5-minute drive ended up with 2 trips out of state, thousands of dollars. Do I go because there's no signal?
We can still.
Pause.
We can still hear you, but we are off the air again. One moment, please. For those of you who are here, we had this problem yesterday. We're trying to fix it right now. You can, oh boy. You can hear us and you're on the Zoom. Just bear with us here for a moment. We're trying to figure it out, but I don't think you can hear us.
Someone in the room just texted me and said that they've paused
Okay.
the room, so I'm assuming someone will tell us.
Okay.
Bob,
Yeah,
you
I
might
saw-
cha- Bob, you might change your name.
Would you,
You're listed as Mary Helen.
Well, okay. The person who was texting the people in the video, just let them know we're working on it. We'll be right back with them in a moment, but we are. Our problem is we can't proceed with the meeting unless it's being streamed live.
Been fantastic.
We
Thank
appreciate
you.
your doing it, Madison.
Would you also,
Thank
if
you.
you're texting one of the people
I've
there, would you let
noticed
them know
you
that we can
also,
still hear
Julia,
them?
And I'm just like, hey, I know that name. I know that face.
Yeah, exactly.
I'm definitely getting better because I was like this first meeting, but Jesus.
This is fun.
I had so much I wanted to add about the Catholic here.
I see. Ah, now can you all hear us again? There we go. Okay. We'll see how long this lasts. And we will, I'm going to let Ms. Anderson start again. And so we'll hear from you. And we'll go again for 2 minutes. Are we ready with the clock and everything? And yeah. Thank you. Let's try that again.
Alrighty. Mr. Chairman, members of the committee, thank you. For the record, my name is Madison Anderson. I'm 22 and from Houston. In September of 21, I had just come out of a 2-year relationship, so I decided on the 15th of September to take a pregnancy test. I remember taking the first one, and the line had developed immediately, even before the control. I called my sorority sister to bring me more tests, and I was in disbelief. At one point, I had 5 positive pregnancy tests in front of me. After seeing multiple positive tests, I talked to my sorority sister about my options, and I knew that abortion was more than likely the choice I was going to make. I called Planned Parenthood the next day to schedule my first appointment. The nearest clinic was only 5 minutes away from where I'd lived. On the phone, the representative explained to me about SB 8, which banned abortion after 6 weeks. The earliest they could get me in was a week later. At that moment, I was okay with it because I believed I was only 12 days along. After talking with the clinician, I estimated myself to be about 4.5 weeks. And to my surprise, I measured in at 10.5. I called 20 different clinics after my first visit. Yes, 20. The earliest I could be seen was 2 weeks later at Jackson's Women's Health Organization in Mississippi. The journey that started with a 5-minute drive ended up with 2 trips out of state, thousands of dollars spent. Accessing abortion took 3 weeks later than I wanted it to, and putting my parents, my sorority sister, my health care providers, and who knows who else at risk of lawsuit of up to $10,000. I have more details of my journey in my written testimony. It is so sad that Texas, the place I call home, doesn't have my back or any pregnant person's back in this tough time. With the Reproductive Health Protection Act, Maryland has a chance to step up and have my back. My parents, friends, and healthcare providers shouldn't be at risk, but they are. I urge a favorable report on HB 808. Thank you for your time.
Thank you for your patience. We'll go now to Dr. Spear. Dr. Robert Spear, please. However, now it's your fault, and you have to remember to unmute yourself.
Somehow I thought the technology would do that. I'll
No.
try again. Good afternoon, Chairman Clippinger and members of the committee. My name is Dr. Robert Spear. I'm a resident of Swanton, Maryland, and Garrett County, and I'm an active member of the Mountain Maryland Alliance for Reproductive Freedom. Today, I am reading a statement on behalf of a provider who does not feel safe being publicly identified. This highlights the need to pass HB 808 to protect our providers. This is the statement that I received. In September of last year, the West Virginia legislature passed a total abortion ban with hollow exceptions for survivors of rape and incest. Since then, hundreds of West Virginians have had to flee their home state to access abortion care, and many have come to Maryland. We know what happens when a person is denied an abortion. They face economic hardships, lower credit scores, greater amounts of debt, and often eviction and bankruptcy. They are more likely to stay with a violent partner or raise their children as single parents. These factors combine to worsen childhood outcomes. West Virginia has one of the highest rates of children living in foster care and ranks 45th in the nation for teen births. And West Virginia legislators have set their sights on a new target, trans kids. Legislators are working to dismantle access to gender-affirming hormone therapy for West Virginia minors, care that is evidence-based, reversible, and literally life-saving. At present, HB 808 does not protect this care, which you should rectify immediately. West Virginia is depending on Maryland as a safe haven. When you cross into Maryland on I-68, the welcome sign states, "Leave no one behind." Make good on that promise by protecting clinicians who provide abortion and gender-affirming care, ensuring that West Virginians abandoned by their own state can access this essential health care here in Maryland. Thank you.
Julia Roche.
Hi, yes. Good afternoon, Chair Clippinger, Vice Chair Moon, and members of the committee. My name is Julia Roche, Legislative Affairs Director at the Baltimore City Health Department, here today to represent the Baltimore City Administration in support of House Bill 808. So you all already know what the bill does. I'm going to skip that part. But I want to emphasize that as of January of this year, 12 states, including our neighbor, West Virginia, have issued near total abortion bans. 4 states have very restrictive gestational bans, and 2 states have no clinics at which abortion care is available. These 18 states are home to over 25 million women of reproductive age. This number is even higher, as some people who do not identify as women can also become pregnant. Inevitably, some of these people will, and already have, seek abortion care in other states where it is legal, such as Maryland. The bill will also protect Maryland doctors from being prosecuted for performing care that is legal in our state. Although abortion remains legal here, our doctors may be at risk for prosecution in other states if a person comes here to receive abortion care. In 13 states, abortion is banned except in the case of a medical emergency or serious health risk for the pregnant patient. It is up to the doctor to determine if the pregnant person's life is in danger. We have already witnessed doctors become fearful and unsure if they can intervene in a medical emergency, even if it means that their patient might die from pregnancy complications. The research is abundantly clear that abortion care can be life-saving. A study from the University of Colorado Boulder found that if the U.S. were to ban abortion entirely, the country would see a 24% increase in maternal deaths. Importantly, access to abortion care also empowers people to become parents if and when they so choose. We respectfully urge the committee to protect people from being prosecuted for care that they obtained or provided legally in our state by issuing a favorable report on House Bill 808. Thank you.
Christine O'Donovan-Savada, please, for 2 minutes.
Good afternoon. In the summer of 2018, because of a broken condom and a failure of emergency contraception, I got pregnant. It took several weeks of violent nausea for me to realize that the emergency contraception I had taken had likely failed. When the pregnancy test came back positive, I felt a horrible pit in my stomach, and I felt a total lack of control, like my body had been hijacked without my consent. And my decision was not difficult. I knew immediately that I needed an abortion. Pennsylvania, where I live, has a politically motivated and paternalistic 24-hour waiting period that requires people who have to travel to get to a clinic to go 2 days in a row. And 87% of Pennsylvania counties do not have abortion clinics. So rather than driving 90 miles twice to the nearest clinic, I decided to drive a little further, but just once, to Baltimore. When I arrived, the clinic staff were wonderful. They talked me through what I could expect, made sure I felt safe and comfortable with my decision, and it was a refuge. I also had an incredible network of friends that helped me both financially and emotionally, a job that supported me, provided time off, and a car that I could rely on for travel. But now, with the overturn of Roe, oh no. Cool.
All right. Not to be mean to Mr. O'Donovan-Savada, but if you want to, we'll give you a little over a minute, but we've got to keep going. So continue your testimony, please.
Okay. I also had an incredible network of friends that helped me both financially and emotionally, a job that supported me and provided time off, and a car that I could rely on for travel. But now, with the overturn of Roe, that pit in my stomach has returned. I know to the core of my being that if I had been in a place where I couldn't legally access abortion, I would have found a way to end my pregnancy at whatever risk to my life. And I might not have survived, but I know that I would not have carried that pregnancy to term. 12 states have banned abortion outright. Several have added criminal and civil penalties for patients like me, for clinic staff, and the friends who supported me. And since the fall of Roe, I've been thinking constantly about the people facing the same decision I did, with the same conviction that I had, often with fewer resources and now with more barriers than I had, who are making that same trip to Maryland for refuge just like I did. They deserve every protection that this state can afford them. And the Reproductive Health Protection Act will ensure that if care was provided in Maryland, as mine was, that it is exactly that, health care. Not a criminal issue, not a civil issue. And so for me, for my friends, and for the healthcare providers who saved my life, I urge a favorable report on HB 808, and I thank you for your time.
Okay, quickly, before something happens, let's take questions for the virtual panel. Any questions from the committee? Delegate Bartlett.
Just really quickly, Mr. Chair, I wanted to ask Ms. O'Donovan Zavada, what state were you living in at the time of all of this?
Pennsylvania.
Pennsylvania, okay, thank you.
Further questions? Seeing none, we thank you all very much for your testimony today. That concludes the testimony of those people testifying in favor. There are several people testifying favorable with amendments, and we'll hear from them now. Jessica Emerson, Brige Dumais, Nancy Schweiss, and then virtually, Priya Hay Chatterjee. Okay, I see two. All right, we'll go ahead. Please, Ms. Emerson.
Vice Chair, members of both committees, and happy International Women's Day, everyone. My name is Jessica Emerson, and I direct the Human Trafficking Prevention Project, which provides legal representation to criminalized sex workers and survivors of trafficking. I'm also here in strong support of House Bill 808 with amendments that I'll cover at the end of my testimony. When I testified in the Senate last week, I was frankly shocked to learn that one of the two primary bases for opposition to this bill was the claim that shielding providers from lawsuits related to their provision of abortion care would make Maryland essentially a destination state for sex traffickers seeking to force their victims to get abortions en masse, because in Maryland, these records allegedly would now be hidden from authorities seeking to pursue evidence of a trafficking crime. However, the actual language of this law bans disclosure of legally protected health information, quote, unless the acts forming the basis of the prosecution or investigation would constitute a crime in this state, which sex trafficking is, so this claim is false. Also, their only evidence for this apocalyptic claim was that sex trafficking survivors have abortions. Well, allow me to confirm that they do. And that is because high-risk sexual activity and sexual violence so often form the basis for their victimization. While access to reproductive care is crucial for all Marylanders who can bear children, for survivors of trafficking, this is even more crucial, as restoring, not taking away, control and choice is integral to the process of recovering from trauma, especially that which involves a lack of control over one's own body. But in order for survivors to do that, they need to be able to rely on service providers with which they interact to assist them, whether it be to provide the care, to arrange it, to transport them, or simply to support them. But that's really what makes legislation like Texas's SB 8 so insidious, the type of anti-abortion law HB 808 seeks to defend against. So desperate are its supporters to control the reproductive choice of others that they would attack service providers like me, who are simply trying to support survivors while at the same time exploiting the trauma of those who have already faced exploitation.
Okay.
I would also like to add that across the nation, the majority of states seeking to criminalize abortion are also seeking to criminalize gender-affirming care. As a result, I'd like to turn it over to my colleagues to discuss that, and I urge a favorable report with amendments. Thank you.
All right.
Good afternoon, Mr. Chair, members of the committee. I'll first start by thanking from the bottom of my heart Delegate Williams for introducing this critically important piece of legislation. For the record, I'm Bridge Dumais. I'm the political coordinator of 1199 SEIU. We are the largest healthcare workers union in the nation, representing over 10,000 members in Maryland. We urge a favorable with amendment report on HB 808. Healthcare choices should be made between a provider and their patient without influence from the government, an employer, and especially an out-of-state entity. As a healthcare workers union, we are loud and clear that abortion is healthcare and our providers need protection. We support this bill. We want this bill to pass this year. However, the bill as written is incomplete. Another form of life-saving, essential healthcare is under attack across the nation that we need to protect: gender-affirming healthcare. Our union represents gender-affirming care providers, so we request a friendly amendment to include protections for them too. There's a rise in threats against gender-affirming care providers, just like the ones against abortion providers, coming from the same regressive, extremist forces that do not align with the values of a supermajority of Marylanders. Many healthcare workers who provide abortions also provide gender-affirming care. When we protect one type of care but not the other, we are still leaving abortion care providers at risk. This can reduce access to abortion in Maryland, the effects of which would be devastating, especially as we're facing a dire short-staffing crisis in healthcare. For those reasons, Massachusetts and Illinois both included gender-affirming care in their reproductive care provider shielding bills. Abortion and gender-affirming care are not mutually exclusive. We cannot legislate these issues in silos because interconnected problems require interconnected solutions. And Delegate Martinez, I appreciate your question earlier. The answer is there is nothing in the Trans Health Equity Act that shields providers. That is about expanding health insurance for transgender patients in Maryland. This bill is about protecting our providers, and that is why gender-affirming care must be included. Thank you.
Thank you. Please. Go ahead.
Good afternoon, and thank you for the opportunity to be here today. I'm Nancy Schweiss. I'm here representing the Jewish Community Relations Council of Howard County. We support passage of House Bill 808, amended to include gender-affirming care. Due to the efforts of an activist minority to criminalize medical care, millions of Americans are currently being denied medical treatment by providers in their home states. Efforts are now underway to prevent those same Americans from seeking that care from providers from outside their states. We are alarmed at the threat these legal challenges pose to out-of-state patients, to those that refer them to care, to those who provide transportation, and to Maryland clinicians. Women must be able to access both surgical and medical abortion options. Only the pregnant person in consultation with her medical team is in the position to make the best decision on her behalf. People, including minors, must be able to access gender-affirming care. Transgender youth, working with their physicians, must be able to utilize puberty blockers that prevent undesired physical changes and enable a smoother transition in later years. The Jewish religion supports the right to abortion care and to gender-affirming care. An expert on the subject of fetal personhood in Judaism writes, "The embryo is considered part of the mother and not a separate being. Jewish law states that the needs of the mother outweigh the needs of the dependent life of the fetus in medical determinations. Jewish law also embraces an individual's right to seek gender-affirming care. Abridging abortion care or gender-affirming care violates our free practice of religion. Maryland clinicians must be enabled to act in their patients' best interest, unencumbered by legal obstacles. We urge passage of this bill, amended to address both reproductive and gender-affirming care. Thank you.
Priya Hay Chatterley, please, virtually for 2 minutes.
Good afternoon, Chair Clippinger, Vice Chair Moon, and members of the committee. My name is Priya Hay Chattopadhyay, pronounced she, they, and I'm the Communications Manager at the Baltimore Abortion Fund. I apologize for not being in Annapolis this week. It's been a busy one up here. The Baltimore Abortion Fund, or BAF for short, is a nonprofit that supports Marylanders and people traveling to Maryland for abortion care. We operate a confidential helpline to share information and make financial commitments to help clients pay for abortions, and our volunteers help clients get to their appointments. The volume of patients journeying to Maryland for legal abortion care is increasing. Following the Dobbs decision in the second half of 2022, we spent nearly 6 times more supporting traveling clients than in the first half of the year, and we literally cannot afford to take the threat of litigation from other states lightly. Legal fees could bankrupt small organizations and clinics, and criminal prosecution of our providers could decimate abortion access in our own state. The goal of bans and restrictions is to make it seem so legally risky to support our out-of-state neighbors who are seeking abortion care that even states with strong abortion protections will give up. With nearby states like West Virginia considering bans like their HB 2007 on gender-affirming care, Maryland is also becoming a safe haven for transgender patients. We cannot put trans rights on the chopping block. Abortion care and gender-affirming care are 2 sides of the same coin. They allow gender-marginalized people bodily autonomy and self-determination. In fact, some providers of abortion care, as others have mentioned, also provide gender-affirming care. Maryland has an opportunity to join other fellow visionary states in ensuring that sexual and reproductive health care is both legal and free from overreach by states that seek to impose their regressive views on gender and reproduction on us through litigation and incarceration. We've already widened the scope of who can provide abortion care. We now have an opportunity to provide this care. We urge the committee to return a favorable report on HB 808 and amend the bill to include gender-affirming care as well. Thank you.
Questions for the panel? Delegate Conaway.
Thank you, Mr. Chairman, and thank you, panel, for coming in to testify. I have 2 general questions. In reference to the general gender-affirming care and abortions, is Baltimore the main place for those type of procedures to take place? Do you know? Anybody know? I've heard Baltimore several times. One lady said she drove from West Virginia to Baltimore, so I was curious.
There are places statewide that provide both abortion care and gender-affirming care. I'm happy to get you that list. We are working to put it together right now, and I will email it to you. I will say that Planned Parenthood is the largest provider of both reproductive health care and gender-affirming care in the nation, and there are multiple locations around the state.
Okay, and the last person on the panel to testify, are you Sarah Mackey? No. You're on the end?
To me?
Yes.
Yes.
What's your name, please?
My name is Nancy Schweiss. I'm here representing the Howard County Jewish Community Relations Council.
Okay, because the Baltimore Jewish Council said something similar to what you said, but in their testimony, it says Jewish law is clear that when the life of the mother is at stake, Jewish law not only permits but also actually compels the mother to abort the fetus to save her own life. And I think that you said something like that also. Is that correct?
Well, essentially, the religious argument that is poised, as I understand it, by Catholics is that the fetus has personhood. And as I understand the Jewish representation, a fetus doesn't have personhood. And so, I mean, does that answer your question?
No.
I'm
Do
not
you
sure.
have authority to speak on Judaism or Catholicism? Which one?
I certainly don't have authority to speak on behalf of Catholicism. I do have 2 links in my written testimony. If you'll notice, the one link is by Rabbi Susan Grossman, and that actually reflects the conservative position. That's from the legal authority of conservative Judaism and what their position is on abortion.
When you say that, are you saying that this is information that comes out of the Torah or the Haftorah, or what are you saying?
Well, not being on an expert on the matter, but you know, Jewish law, it's a lot like American law, and situations come up that aren't necessarily anticipated by the Torah, but the rabbis who determine the Jewish law do sometimes base that on TOA precedents when they find that. And as a matter of fact, if you'll see the reference, you'll see that they do have kind of a theoretical foundation based on something from Exodus there.
Yes, I understand. Thank you very much. Thank you, Mr. Chairman.
Further questions for this panel? Seeing none, thank you all very much. We'll hear from the person testifying in opposition. Lisa Bogley, please. Or I'm sorry, Laura Bogley, please. Laura Bogley.
Good afternoon, Chairman Clippinger and members of the committee. I'm Laura Bogley, Executive Director of Maryland Right to Life. I appreciate the opportunity to speak with you. On behalf of our Board of Directors, we strongly oppose this bill that enables abortionists to traffic and exploit women for profit. By enacting this legislation, the Maryland General Assembly threatens to become a state sponsor of interstate human trafficking, may aid and abet sex traffickers, and will abandon your duty to provide for the health and welfare of residents and non-residents alike. Despite what the proponents say, and I don't have time to correct all of the fallacies you've heard today, this bill will not protect women like Jennifer Morbelli, who traveled here from New York to get a late-term abortion and died at the hands of her late-term abortionist licensed to practice in the state of Maryland. Proponents have admitted this is an abortion shield law, and it's designed to circumvent Article 4 of the Constitution and protect abortionists instead of women, to protect sex traffickers instead of women, those traffickers who transport women and girls across state lines to get unregulated and late-term abortions, as well as abortion drug dealers who peddle their deadly wares across state lines through teleabortion. The connection between abortion and sex trafficking cannot be denied. Abortion centers that turn a blind eye for profit enable the sex trafficking industry. Several undercover investigations have documented their failure to report rape and sex trafficking. A groundbreaking study by the Beasley Institute found 66 human trafficking survivors had a total of 114 abortions. Nearly 30% said they went to Planned Parenthood. One survivor who endured 6 abortions recounted, quote, "At least one of my abortions was from Planned Parenthood because they didn't ask any questions. You went backdoor where the charge was more like $150, end quote. I also want to note, while I have time, that I worked with the state police last year after the Dobbs decision, and in working with state police, we learned that there were 0 reports of violence against abortion providers. But there were 2 reports of vandalism against pro-life pregnancy centers. So we urge your unfavorable report, and to safeguard women, keep the safeguards for women in law. I'm happy to take questions. Thank you.
Questions now, Delegate Grammer.
Thank you, Ms. Bogley. Can you just generally speak to the idea that abortion is health care and women would be protected under this bill?
I don't know that this bill, any more than anything else that we've seen, Delegate, pretends that abortion is health care. I think it's pretty brazenly protecting or shielding the providers. It's not necessarily concerned with the standard of medical care that women are receiving in Maryland. And that is the point of our objection, is that Maryland is passing regressive policies that don't protect women or ensure health and safety standards for women seeking abortion. Abortion is legal. It's going to remain legal through all 9 months of pregnancy. But this assembly has removed all safeguards in law for women's health and safety. And this is just one other assault against women where it will hinder their ability to get legal redress for injury or death caused at the hands of abortionists in this state.
Thank you.
All right, thank you. This bill has to do with protecting the, abortion providers. Do you know if there's any such laws that protect pregnancy support centers?
There are no similar or equivalent laws that support pregnancy centers. Pro-life pregnancy centers in the state of Maryland receive no public funding. There have been attempts in recent years to close pro-life pregnancy centers and put them out of business. And courts in Maryland have upheld the rights of pregnancy centers to continue to offer life-saving alternatives to women in the state.
Thank you.
Further questions? Seeing none, thank you very much. And that concludes the testimony on our first bill, House Bill 808. Okay. 3:47 now, everybody. 11:17, Delegate Boyce is here. See if we can do what we can. Kelly Ray?
Yes, can she come up with me?
Yeah.
Yes. I hope to not be before you long.
All right.
I pray.
All right, so we're going to hear from you, Delegate Boyce, for 3 minutes, and then Ms. Kelly Ray for 2. And then we have one person testifying in opposition. I've got to step away for a moment. I will be back in just a bit. Thank you.
Thank you so much, and good afternoon, Chair Clippinger, Vice Chair Moon, and members of the House Judiciary Committee. For the record, I'm Delegate Regina T. Boyce, here to present HB 1117, Family Law Adoption for an Adult. HB 1117 alters the provision of law for adopting an adult, 18 and over, to include the termination of parental rights, TPR, investigations of the parent, and a home study where necessary. Adult adoption is common and occurs for a myriad of reasons. Some of those reasons include inheritance, medical decision-making, death of parents or relatives, stepchildren, or moving from a long-term foster relationship. In the case of my constituent, she met the general parameters to adopt her son under the adoption laws. Those under 18, abandonment, abuse, and lack of financial support. For instance, the adoptee was also international, with one parent in the United States and the other in another country. However, given the age of the adoptee, 18 and over, the process required a host of steps deemed unnecessary for someone considered by law as an adult. After years of going through the process, time and money, this past winter, my constituent, through a court appointment by Zoom, officially adopted her son. To ensure no one goes through such an arduous ordeal, or at times unnecessary process, my constituent seeks to change the law. And with that, I also want to add that I have spoken to the Department of Human Services, who internally, I believe, is working on their own adoption potential procedures, but has requested an amendment that I do support. And with that, I urge your favorable report. Good afternoon. Mr. Chairman left the room. Mr. Vice Chairman, delegates. My name is Kelly Ray, and I'm here to share my story. I adopted my former foster son, Carmelo, last November. He was 27. It was finalized by Zoom, as mentioned, with a judge in less than 10 minutes. It took us nearly 5 months and me about $3,500 to get to that day because of the current laws and regulations. I thought it was absurd that an able-bodied adult could not make this decision on his own. I didn't care about the money, but I also found out it could be a lot more. I was very fortunate. And there's no cost high enough for me to adopt my son, and I could afford it. Others cannot. So I started researching how other states handle adult adoptions. Most have their own adult adoption statutes, and it's time for Maryland to change their law, and I thank Delegate Boyce for bringing this bill to your attention. Carmelo entered the foster care system just 24 days before his 18th birthday, was with another family until I was cleared to be a resource parent when he came to live with me about a month later. He moved into his own place at 19 and a half with continued support from the state and bought his first house when he was 20. We did not talk seriously about adoption until he was 26 because he was also an immigrant, as mentioned, and he had to wait until he became a U.S. citizen, an 8-year journey for us. The other reason for the delay was because he didn't want his birth person to know his business. And he is right. She has no need, no right, and no privilege to know his business. And the emotions it brought up for my son, just thinking of the past, was traumatizing, and you have his testimony. If you read it, you will see why. I have promised him I will never bring this up again and make him write about it. Some ask me why and why now. Carmelo and I never needed a piece of paper to know we were mother and son. He plans to enter law enforcement, and even with power of attorney, his birth person could make things difficult if decisions have to be made if something happens. Now she has no say. Because adoptions are confidential and there is no adult research to back it up, I can't use that. My plea to you today, for the sake of the privacy of adult adoptees who just want to be part of a loving family, is to return a favorable report on HB 1117. I have also seen the amendments, and I'm in favor of those as well. Thank you.
All right, I don't see any questions, so I guess that's straightforward. We do have
virtual Vince McAvoy signed up in opposition. If he is with us? Okay, great.
Thank you so much, committee. I appreciate it. Trying to get rid of the echo effect. I am against this bill. It is rather convoluted, this process, because it's not very much used. There are intestate issues getting into this particular one and the scope, as well as the issue of not having an investigative end to that, is a problem. And I want to highlight something that was very disturbing that I found about how this was used in the 90s. If I can find the quote here. It very much surprised me and was very difficult to read. This is from legaldictionary.net, adult adoption. Adult adoptions may also be done to create inheritance rights, and that's what this usually is applied for, not for parentage issues. Interesting, was commonly used within same-sex, especially in the 80s and 90s when HIV/AIDS was at its peak. The issue was that adoption created a parent-child relationship which would legally be classified as incest. And so when I say that in addition to inheritance issues, in addition to intestate issues, and as in this particular case, I do have people looking into this issue from legal immigration aspects. They have not got back, so I'm not going to testify on that part, because I'm not an expert in that area. But it opens up a can of worms that need, because we just don't have that many cases. So I am against the bill, and I thank you for listening, committee.
All right, I don't see any questions, so that's going to end the hearing on
Thank you
House
so much.
Bill
Thank you.
1117. Do we have someone from the city for House Bill 865? Delegate Smith? No, maybe not. Or Ebersole? All right.
I think they're on the Senate side.
All right. All right, give me 1 second.
It's Lisa, probably because she thought we were going last. Can I, Mr. Vice Chair? Yeah, if you could check with Lisa, please. Yes. And we'll go ahead and begin. To Vice Chair, members of the committee, N. Scott Phillips, District 10. This bill we bring before you, and it's really simply to change one word, quite frankly. And this bill came to me because of a story. Now, I won't go deeply into the story, but subsequent to the story coming to me, I had a parent call me. And the parent said that her child had been, was being basically extorted. And the child was being extorted for sexting. And the parent wanted her child to file a complaint. And the child's biggest issue was they didn't want to file a complaint because they didn't want anybody to know who they were. And so, looking into this, currently our law allows for a charging document to include the name of a victim or a witness. In practice, often state's attorneys do not do that. But if you read the way the code is written, it is a may. And so What we're trying to do today is take a may to a shall. That we protect child victims and witnesses from the potential that their name would be listed in a public document associated with a court matter. It's as simple as that. Federal law actually addresses this today, right? So if you look at 18 U.S.C. Section 3509, and we're not going as far as the language in federal law, but it requires that all government employees connected with a criminal proceeding, all court personnel, the defendant, all employees of the defendant, all members of the jury cannot disclose the name or any other information concerning a child, and such information must be kept in a secure place to which no person who does not have reason to know their contents has access. We didn't go that far. We're just saying that when you do these documents, you shall redact the name of the child. We also say that if there is a reason, a compelling reason, that the court decides that that name should be available, then the court can make that decision. But we reverse it, because today, if I don't want the name, I've got to go to the court and ask the court to redact the name. So therefore, I ask for a favorable report on House Bill 1032. Thank you, Mr. Vice Chair. I'll go to Mr. Padone.
Mr. Chairman, Mr. Vice Chairman, members of the committee, thanks for the opportunity to speak today in favor of House Bill 1032. My name is Michael Padone. I'm a Maryland attorney. I have to note that the views I express here today are solely my own, don't necessarily reflect the views of my law firm. First, I want to thank Delegate Phillips for his leadership on this bill. And I just want to amplify some points from my written testimony with an example from the real world. A 15-year-old girl was repeatedly raped by a 34-year-old man who was the manager at her first part-time job. She summoned the courage to disclose these crimes to her parents, and the family sought my advice. The girl said to me, "I don't want everyone at school knowing about this. I'm not pressing charges if people can find out who I am." And this is important. It was the prospect of being outed as a victim that was a deterrent to this girl reporting these horrific crimes. Bravely, she decided to press charges. The rapist was arrested. A few weeks later, a grand jury returned an indictment, and every count of that indictment contained her full name. She was shocked. Using common sense, she reasoned that the law couldn't possibly allow the name of a child rape victim to be plastered all over public documents. Even the legislative analyst who wrote the policy note for this bill pointed out that, in general, police and court records concerning children are confidential, because that's what people typically assume. But the law doesn't always align with common sense or function as we assume it should. Currently, nothing in Maryland law prohibits the disclosure of the identity of children who've been victims of crime. And believe it or not, when a child is a victim of a crime like rape, Maryland law requires that their name be disclosed in charging documents. Federal courts have solved this problem by requiring redaction of names of minors in court filings, and HB 1032 would essentially clone that approach in Maryland. It's an easy fix. I therefore urge the committee to issue a favorable report on HB 1032, and I'm happy to take any questions.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're also here in support of House Bill 1032. I don't want to repeat anything that's already been said, but you know, it really is important for survivors of sex crimes to have privacy. And I very much appreciate Delegate Phillips introducing this bill. He used a very measured approach. I have to say it's a lot more modest than the federal law, and so perhaps the subcommittee will also look at that. I don't want to slow the bill down, at least go this far. And I would also just draw the committee's attention to Criminal Law 317, which requires that a victim's name be included in an indictment information or warrant for certain sex crimes. So, you know, I've handled a lot of cases. I've seen a lot of charging documents. A lot of the time they do not include the name of the child victim, but that appears to conflict with our actual statute. So you really should fix this so prosecutors and others are not violating the law when they are trying to protect child survivors who are so brave and coming forward to indict rapists and help protect the entire community. For those reasons, the Maryland Coalition Against Sexual Assault urges a favorable report on House Bill 1032.
All right, we're going to go to Scott Schellenberger online for 2 minutes.
Good afternoon, members of the committee. Sorry I couldn't be there in person today. I'm here in favor of House Bill 1032 as a very simple and logical step. As you can see in my written testimony, I attached the original charging document in the case that recently occurred as a result of a teacher at Gilman. The statement of charges is able to just say the victim. But as Ms. Jordan correctly points out, 3317 required that when we went for an indictment just last week, we had to put the victim's name in there. Now, under the current statute, Criminal Procedure 11301, we can ask that the victim's name be shielded, but it has to be in the indictment because we have to turn all that over to defense counsel and the discovery that they have a right to, which we certainly agree and understand that. So what we're doing here with HB 1032 is now automatically shielding minor victims' names, no longer requiring me to make sure my people have found it in every count, to make sure we go to a judge, to make sure we get a court order and get that shielded. We think this is a very sensible and logical first step. Victims, all victims have a right to have shielding, but clearly victims who are minors, it should be automatically done so that we don't have to make a mistake and go through the process. I urge a favorable report. Thank you so much, Delegate Phillips, for putting this in.
Delegate Grammer.
Mr. Chair, I have two questions, and this reminds me of a case I had in my district. I had a young girl, and she had a boyfriend, and he was abusive, spiraled out of control, and what he began to do is he would choke her to the point of unconsciousness. She would wake up, would choke her to the point of unconsciousness. Again, right in front of her child, he would do this over and over and over. She was faced with a situation where she either pled and got a very minimal penalty, or she would have to go to court, and she would have to go through all these charges. It was the exact same situation, and she said, "I don't want to put all my information out there. We're going to be done with this." I have two questions. Do we or do we not have a big problem with producing witnesses and victims because of this exact problem? They have to go public. They don't want their information to be out there. Can you speak to that briefly?
So I don't know what the statistics are, Delegate Grammer, but I can tell you I am certain that there are individuals who do not come forward because they don't want all of their information publicly available so that they can become martyrs in this particular situation.
My second question is for State's Attorney Schellenberger. I believe what the judiciary is arguing here is that they're not going to be able to have proper discovery. Can you help me clarify how this bill protects that?
So discovery is not put in the court file. We give discovery directly to defense counsel. So in the police reports and the statement of charges and the indictment, where we would shield anything that would go into the public record, we would not shield the information that goes to defense counsel. We have had that arrangement for a very long time. I cannot recall off the top of my head in 15, 17 years of any defense counsel violating that by publicly outing the victim. And so I think that does have to be revealed in discovery, but that is very different than what has to be in the public record.
Okay, thank you.
All right, thank you very much. Doesn't look like there's anyone signed up to speak against the bill, so that's going to end the hearing on House Bill 1032.
Thank you, Vice Chair.
Thank you.
Thank you.
Let's quickly skip to House Bill 1053. This is Delegate Ebersol, and it looks like this is a one-person bill hearing. So, Delegate Ebersol, whenever you are ready.
Mr. Chair, thank you very much for your consideration. I don't get to testify in front of Judiciary too often, so it's very exciting for me. A little bit nervous, because you're the smart ones, right? Don't tell my committee I said that, or go ahead. Yeah. Tolls, I was hanging out with you before, right? I'll get you next time. Okay, thank you. I've had a series of bills, and interestingly, each one has ended up in a different committee. Several years ago, I came up with the idea of having truckers be trained and understand what human trafficking looked like, what was unique about it, and how to report it. That went to Environment and Transportation. Then I brought it up for hospitality, for hotels and motels, and it went to ECM. And this year, we've moved on to public transportation and other forms of transportation. And I've been lucky enough to land in what would be the jackpot, the third star on the machine in Judiciary. And so this is, the bill is pretty straightforward. It says that, and it's pretty broad, we have a pretty broad category, so I'd be interested to see how you all react to that, but that people who work in public transportation, for taxi companies, for ride shares, in transportation hubs, will need to be on an annual basis given access to training and understanding what human trafficking looks like and be able to report it. And the bill includes some good Samaritan language if they misunderstand what they see and report it incorrectly. The idea is to take a bite out of this. Our understanding, this may be the most significant one yet because so many people who are human trafficked are moved in ride shares, in cabs, in buses around. And so if there's ways for them to be recognized, airports tend to do it already because they're interstate, but I think in our state we need to make sure that we give these people who are being human trafficked, often women, but not always, every chance of being noticed and every chance of being bailed out. So the bill's called See Someone, Save Someone, and I hope that's the case. And with that, I'll take questions if you have them on the bill.
Delegate Tolles?
I was going to get you.
Okay, bring it on. Let's go.
No, I'm not going to say anything, but congratulate you on a good bill. When I was on the council, I did a bill for hotel workers to get training so that they are aware of human trafficking. So I did a lot of 2 or 3 different human trafficking bills, massage parlors to be trained. So I just want to congratulate you, my friend, on a wonderful bill.
Well, you laid the groundwork for the statewide bill, which is in place now, that hotels and motels have to train their workers.
Oh, you make sure you tell people that Tolls
Yeah.
laid that bill. My buddy here.
Tolles laid the foundation for my bill. Thank you.
No, I love it. No, this is a great bill. This is another area that needs to be trained. So kudos to you.
Thank you very much.
You're welcome. Thank you, Mr. Chair.
Delegate Schmidt and Pasteur.
Thank you, everyone.
I thought you were just keeping me in suspense there. I'm not going to ask my question yet.
That's right. Thank you, Delegate Ebersol. Can you share with some of your past bills that have been passed and the success of those?
Right. Well, I'd name the other 2.
Yep.
Like I said, and the key to this is, by the way, is that we changed one word. I think we got it in, but if not, it should be amended. It says that MDOT should develop training. You don't need to develop training on this. There are trainings everywhere. And so there's a group called Truckers Against Trafficking, which got me originally interested in this, and they were very eager to have truckers be trained. And also there's a bunch of stuff about providing some stickers and things around so people can see the numbers. Also, the people who are being trafficked might see them as well. And so then we got to thinking that hotels and motels obviously were places, and we're not just training people at the front desk, we're training, housekeeping staff and maintenance staff and everybody, so that if they saw it, they could say something. And we've just moving slowly through it, and obviously it's a good thing because they all end up in different committees, but this year we thought we really should look at public transportation or ways that people are transported.
Yeah, I guess I've seen it in airplanes.
Yes.
If I'm not mistaken, and maybe bus or bathroom stalls.
Right. So
in
there
some
are
places.
federal laws on this.
Okay.
And they apply to interstate travel.
So this expands that.
Right. You'll be
Okay.
sitting waiting for your airplane, and you will see it come up on the screen when you're figuring out what seat you're in. It will also remind you that human trafficking is a crime.
Okay. Great. Thank you.
You're
Thank you for
welcome.
bringing it.
Thank you.
Thank you.
Delegate Pasteur.
Thank you, Vice Chairman. Delegate Ebersol, this is a wonderful bill indeed. But what is really, really strong about it is that you hit so many levels, not just putting it out there to signage, but for awareness. We have a lot of that, a lot of misinformation that you see on television shows, and so people think it's somebody else that it happens to, but you include the awareness, the training. Talk about the signs, because sometimes we have our signs up and out and about, but there's nothing that really takes us to the new level in terms of awareness.
Delegate Pastor and I are office mates. I'm going to move some of her furniture
gosh.
around.
I was trying to be cool.
But I read this in the fiscal note, and I think it was a misunderstanding. And if it needs to be cleared up in language, fine. It says that we want some signage. By signage, we were thinking stickers that you put in practicable spots, like on, bus shelters and various places. We didn't mean that they had to install new signs. According to the fiscal note writer, it costs $400,000 to put in a new sign, which, by the way, I was thinking of resigning from the legislature and moving on to being a guy who puts up signs places, because I think it would be quite lucrative for me. So if it needs to be corrected in a way that it's understood more clearly, the idea was you just have some stickers that go on buses, that go at stops where and you can say we're practicable, to try to alert people of what they're looking for. And there are things, I don't know if you've done this, but little things that I learned that I didn't know is like a tattoo with a number on it on someone's arm is a very clear indicator that they are being trafficked. And so there's, if you see somebody being moved around, and that's true, there are other things, and there's a whole bunch of them, and they're in the trainings. They're not just, this is a bad thing and you should look for it. It gives particular characteristics that people can look for. And so thank you for that question.
But if I may, just to extend on that, as you talk about the tattoos and also barcodes, et cetera, that you'll see. So when you put these signs, the $400,000 signs, when you put them out there, though, will you include on the signs, or will you think about including on these signs, not just the words, but some of those signals?
Maybe it might be too much for people, but it wouldn't be a bad idea. What's going to definitely be on it is the hotline number.
Yeah.
Okay, so that if you've seen, that if you're not sure, you can call. And like I said, we have Good Samaritan language, which protects people from if they've called and they're wrong.
And I don't mean anything graphic with somebody, that's graphic, but just something that triggers. Sometimes when you don't have any words at all, that is just as powerful.
Correct.
As
and we have some language in there also that says, the announcements that you hear occasionally, the routine ones about not leaving packages and that sort of thing, that somewhere in there should be that. And if MDOT felt like it was appropriate, they could put in specific things. I'm going to leave it up to the agency to decide what would catch people's eye and what would be effective and what won't. But, I hope, quickly, anecdotally, this was the first thing that anybody ever talked to me about when I decided I was running. The pastor at my church sat me down and said, human trafficking is a problem. Did you know this? And I didn't really. He said, it's happening right under our noses. So I often go back to him and say, you started this. So there you go.
Did you know it happens in schools as well?
Yes, and people get human trafficked without staying overnight. Sometimes they get human trafficked just in the afternoon. And, we have in Ways and Means bills to create awareness for kids so they understand if they're being human trafficked, in fact, because sometimes they think it's normal what they're doing. They're going and hanging out with these people and doing what these people tell them to do, and that's normal and okay because, nobody's told them otherwise. So you can be human trafficked and then come home to your house later that night, maybe, and do whatever things you do or don't do. So human trafficking doesn't mean you're necessarily being moved from state to state, although it certainly can mean it. And you all know that this area, the Baltimore-Washington area, is ripe because of the confluence of interstates and the harbor and the railroads. We are really one of the ones that has to battle it the most, actually.
Thank you.
Sorry, longer answer than that wasn't really the question.
All right, and it doesn't look like anyone signed up to speak against your bill, so that's going to end the hearing on House Bill 1053.
And I'm grateful to you for letting me testify. Thank you.
Let's jump back to House Bill 865. Delegate Smith, I saw her. I know she's nearby. I just saw her a second ago.
The delegate had to step out for a 4:30.
Ah,
Is it
so
okay?
she's not coming back?
She will not be here for this bill. I'm from the Baltimore City Administration, and she introduced the bill on behalf of the administration.
We need a staffer. Yeah. Okay, she says to go without her. All right, whenever you're ready.
Sure. Good afternoon, Vice Chair Moon and members of the committee. My name is Nina Themelis, Interim Director of the Mayor's Office of Government Relations, here to testify on behalf of the Baltimore City Administration on HB 865. This legislation is a result of the convening of the tax sale work group, which was convened by Mayor Scott in the fall of 2021. This group met over the course of a year and discussed ways to improve outcomes for residents who have had their properties sent to tax sale. HB 865 would allow for the heirs of properties to be able to enter into payment plans for unpaid taxes and other fines and fees that have resulted in a lien against that property. This allows the heir to clear the title for the property and have the property transferred into their name. This will help to reduce tangled title issues and enhance proper options for increasing generational wealth. Additionally, this bill would allow for the heirs to be eligible for assistance programs that they would not have been eligible for without the property being able to be transferred in their name. I have here Stephanie Murdoch from the Department of Housing and Community Development to testify in support of this legislation as well, and we request a favorable report for HB 865.
Thank you, Nina. As Stephanie Murdoch, I am with Baltimore City Department of Housing and Community Development. Thank you, honorable members of the committee, for the opportunity to testify in support today of HB 865. Baltimore City DHCD has a small team that works to educate residents on what tax sale is and how to help avoid it. Unfortunately, we are not able to assist a number of individuals who struggle to pay their bills, even though they have lived in a property, maintained that property, and paid its mortgage, property taxes, and other bills, sometimes for years, because their name is not on the deed. The state's homeowners and homestead property tax credits and the Homeowner Assistance Fund, the city's emergency mortgage homeowner assistance program, the tax sale deferral program, the city weatherization program, housing rehabilitation, and lead hazard reduction programs are all unavailable, though they are all intended to promote and preserve homeownership and maintain and improve properties of our most vulnerable residents, and that's because their names are not on the deed. Maryland Volunteer Lawyers does a great job through the My Home, My Deed, My Legacy program to help provide pro bono legal assistance in resolving property ownership issues, but is not a remedy for the systemic barriers that regularly add new names to its client base. Probate fees, outstanding property taxes, and other bills thwart those seeking the transfer of property that has sometimes been in the family for generations and blocks the most effective path towards building generational wealth, legal property ownership. Instead of promoting homeownership, improving and maintaining properties and communities, and building homeownership, more potential tax sale and vacant properties are become deteriorating homes. House Bill 865 provides a much-needed reprieve for potential Baltimore City homeowners who could, with additional time and assistance from the previously mentioned resources, could manage to stay in their homes. Thank you again for your time. We stand by in support.
All right, we have a few more people signed up. Do we have Odette Ramos, Margaret Henn, Nicole Hart, Dan Ellis?
So I believe Councilwoman Ramos, Dan Ellis, and Nicole Hart are participating in a hearing in the Senate at this point in time, so they haven't been able to make it over yet.
Okay, great. All right, whenever you're ready.
Thanks. Good afternoon. My name is Margaret Henn. I'm the Deputy Director at Maryland Volunteer Lawyers Service, and as was mentioned, our My Home, My Deed, My Legacy program assists clients who live in tangled title properties. What this means is often that the deed is in someone's name who's deceased, and our clients are the heirs that are living in that home. they most often come to us when they're facing some kind of crisis. So that could be a tax sale, a foreclosure, a major home repair that they need. But as you know, or as you may know, the clients often face a bit of a chicken and an egg problem where they can't get access to tax credits or the grant or loan programs to fix up their homes without the deed in their name, but they can't get the deed in their name without paying off the property taxes that are owed. And the property taxes are by far the biggest barrier we see to heirs in tangled title properties being able to transfer the deeds into their name. During my time at MVLS, I have seen that this has particularly devastating effects on Black residents in Baltimore and often strips their families of their main asset that they have worked very hard for, which is their home. This bill provides what I believe is a logical solution, which is to be able to both transfer the deed while helping these individuals to enter into a payment plan so that they are still continuing to pay those property taxes that they owe. One client that I've worked with found herself in kind of a similar situation. She had been caring for her mother. Her mother was very ill at the end of her life and left her home in her will. However, my client, her mother was getting the homeowner's properties tax credit, and then when she died, my client wasn't getting it anymore. She fell behind her taxes, and even though she was willed the property, she couldn't transfer it into her own name. It took her several years to successfully do that, and my assistance for over a year. A payment plan like the one envisioned in this bill would have allowed her to make that transfer and make much-needed repairs to her home. So for those reasons, I support a favorable report on this bill. Thank you.
Delegate Taylor.
Thank you, Mr. Chair. Is Baltimore City unique in some way that this provision, I know Baltimore delegation brought the bill, but is it unique in some way that this provision is solely focused on Baltimore City? Could it be that other jurisdictions might have the same need but just hadn't thought about it, and could we include them?
So we didn't engage in conversations with other jurisdictions. So this year, at least initially, we wanted to ensure that the city was able to pursue the opportunity. I'm sure other jurisdictions may find themselves in similar situations.
Yeah.
I believe the vacancy issue in Baltimore City is one of the highest in the state. So we want to make sure that as much as possible, we're able to keep people in their homes and not increase that problem. But we'd obviously be more than happy to engage with other jurisdictions to have that discussion. But for right now, we just wanted to make sure we started the conversation with the city.
Could we possibly have that conversation before this bill moves further?
We could certainly
further
do that.
along?
Yes.
Okay, thanks.
Delegate Schmidt.
We'll try this again. Thank you, Chair. You might have mentioned this. How often does it happen on an annual basis?
That there's a tangled title
Sure,
property.
yeah.
Well, as far as the data that we have on our own clients who are on the tax sale list, it's about 20% of them that are in these tangled title properties. And on Baltimore City's tax sale list, when you look at residential properties, that's 6,700 this year.
Okay.
So I don't know exactly what 20%
Like
of that is, but it's
1,500 or so, maybe a
yeah,
little bit more.
yeah.
something like that.
You know, at least a couple hundred, if not over 1,000 individuals just this year.
Yeah, I mean, it's interesting, and also what Delegate Taylor had mentioned, it could be a statewide problem or a statewide opportunity that we could be looking at.
Yeah, we certainly wouldn't be opposed to that.
Yeah, we believe it is a statewide problem, and the scale of the problem in Baltimore City is particularly large.
Thank you.
All right. There doesn't appear to be anyone signed up in opposition to this bill either, so thank you very much. That's going to end the hearing on House Bill 865. We're going to move now to House Bill 1116 from Delegate Bandari. And I think this is another one-person hearing, so whenever you are ready.
Good afternoon. For the record, I'm Delegate Harry Bandari, represent Baltimore County District 8, and come from Health and Government Operations Committee. Chair, members of the Judiciary Committee, I'm here presenting work group to study Extreme Risk Protective Orders, Sagar Gimire Act. By all accounts, Sagar Gimire was a bright young man with a very promising future, an aspiring data scientist who had just graduated from Clifton University. And he moved to Baltimore County in 2021 in hopes of attending graduate school. While settling into a new home in Woodlawn, he was killed by a neighbor with a history of very erratic and violent behavior. He was just 24 years old. I was devastated when I heard this news, and I rushed to the scene to offer whatever help I could to the community and those who knew Sagar, as well as 2 others who were killed and more were injured in the same incident. My grief is nothing compared to what his family felt as they gathered from across the country and his home country of Nepal to mourn his passing. In the days and weeks which followed, there was one thing they wanted: justice. The perpetrator of this incident had a history of run-ins with the law enforcement. Neighbors reported that he often confronted them, accusing them of spying on him for the federal government. One resident who had registered his concern to the police said, in the Baltimore story, the situation was like a ticking bomb. Tragically, he was caught in the blast, and his family was left to wonder why. If the clues were there, was no action taken which might have prevented this incident. I asked this question to our local law enforcement and Baltimore County State Attorney and County Executive. I combed through the incident report to try and identify what could have gone differently. It was 90 pages long investigation. I could not get a clear answer. This bill would take a step towards providing that answer. At Sagar's memorial service, I share my deep sadness at his loss and my anger. As I said then, Sagar deserved more. He came so far and achieved so much. He was right at the age of the rest of his life. And then it was all cut short. It was simply an injustice, and I was angry. I'm still angry. Sagar's death could have been prevented if we continually strengthen our system safeguard and support those experiencing mental health crisis. Many lives will be spared. We cannot rest easy, knowing that more families will be burdened with this grief, and we cannot allow this to happen in our communities without doing everything we can to stop it. That's my place. Then I'm fighting to make this, the justice for everybody. I know due to the lack of time, Mr. Chair, in the slide, I request a favorable report. There are the testimonies uploaded by his family members. Due to the technical reason, they could not be here. Thank you. If you have any questions.
I don't see any questions, so thank you very much. That's going to end the hearing on House Bill 1116. We're going to move on to House Bill.
Thank you.
Thank you. 952 from Delegate Mangione. Also a one-person hearing, so whenever you're ready.
Thank you, Mr. Chairman and the members of the committee for the opportunity to present HB 952. This is the Violent Firearms Offender Act, and this is the exact same bill that Governor Hogan has put forth in years prior, so I won't take too much of your time, as most of you, although I know there's a lot of new people, most of you have heard this before. I decided to introduce this bill just a few weeks back because, of course, crime is the #1 issue in the state of Maryland right now. Just a couple weeks ago in Towson, a young teenager was killed in Baltimore County, an area that is known for relatively low crime. Just earlier this week, another teenager was shot and killed in a playground in Baltimore City. We all share the same concerns when it comes to crime, keeping communities safe, and I believe this bill, which is designed to go after repeat violent offenders, it really does help move the needle in achieving those goals. One of the main components of the bill says that an individual that uses a firearm in the commission of a violent crime for a first offense, imprisonment for no less than 5 years, and second offense for imprisonment no less than 10 years. It also takes an individual convicted of theft of a firearm and makes them guilty of a felony. There are other provisions in this bill. It's all right there in front of you. What this is designed to do, really, again, is to get send a message that this state is no longer going to tolerate violent crime by effectively punishing those. If you commit these violent crimes, the state of Maryland will no longer allow you, especially repeat offenders, to walk the streets. So thank you, Mr. Chair, for your time and the opportunity to present this bill.
Okay, I don't see any questions on this one either.
Perfect.
Thank you very
Thank you.
much. Yep, that's going to conclude the hearing on House Bill 952. Do we have Delegate Grossman here? Or? She's on her way. Okay. Talk amongst yourselves. Do you want to go, McComas? Are you ready to go? Yeah. Yes. Yeah, this is going to be quick.
Okay.
All right, whenever you're ready. This is we're going to start the hearing on House Bill 1070. Delegate McComas.
Thank you. Delegate Comas in support of HB 1070. This bill authorizes a licensed certified social worker, clinical, LCSWC, who is licensed under Title 19 of the Health Occupations article and qualified as an expert witness to testify on ultimate issues including insanity, competency to stand trial, and matters within the scope of the social worker's special knowledge in any court or administrative hearing. By passing HB 1070, we are codifying what has already been determined by the Court of Appeals, now known as the Supreme Court of Maryland, in 2010 in the reported opinion by Judge Battaglia. In the case known as In Re Adoption Guardianship of Tatiana B., the Court of Appeals recognized Section 19-101F of the Health Occupations article defined the practice of clinical social work as rendering a diagnosis based on a recognized manual of mental and emotional disorders. It went on to affirm that a licensed clinical social worker is specially authorized by the legislature to render diagnoses based on a recognized manual of mental and emotional disorders. Summing it up, the court stated that it is clear from the plain statutory language that the legislature deemed licensed certified social worker clinical capable of rendering diagnoses such as those made by the licensed clinical social worker at trial. In conclusion, the court held that there is nothing that bars an LCSWC from expressing an opinion as to the existence of a mental disorder based on a recognized manual, as the licensed clinical social worker has extensive education and experience in the field from which a trial court could properly conclude that they are qualified to testify as experts. Unless cited within the Courts and Judicial Proceedings article as proffered by this bill, highly trained healthcare workers, LCSWCs, will not reach their full employment potential despite their vast knowledge and experience. HB 1070 is merely a statutory rendering of an opinion promulgated by the highest court of the state of Maryland in 2010. Please support HB 1070. And I just would like to say that I did get an AG opinion, which was not in the packet, but basically Sandra Bentley indicated that it is constitutional, and I will provide you with a copy, Vice Chair Moon. And the other thing I would just say is that the bill says may, so obviously the court between the attorneys could fight over, well, is the LCSW clinical competent to testify or not, and that's really the judge's decision. So this was the as an expert witness may testify, so it's not preordained that they shall testify. This is a may bill, so it's got to jump through the hoops of the trial the trial judge. Thank you.
Listen. It's okay now? Okay. Good afternoon. This is I'm Arthur Flax. I'm a licensed certified social worker clinical. I have a diplomat in clinical social work. I have been trained going back to 2004 at Clifton T. Perkins Hospital in forensic evaluations. I received from Clifton T. Perkins, I used to receive from them patients to see for aftercare. Because of the situation as to whether or not we could testify on the ultimate issues of competency and criminal responsibility in some other areas, Delegate Sandy Rosenberg on January 30th, 2004, with the Attorney General's opinion written by Kathleen Rowe, affirmed that a licensed certified social worker clinical may be permitted to testify with respect to ultimate issues such as sanity and competence to stand trial. However, the way the case law read, it's difficult to interpret. And unless you have the AG's opinion and so forth with you, it's hard to get to be able to. They look back at the statute that the psychologists are under Section 9120 of Courts and Judicial Proceedings, which says a psychiatrist and a psychologist. The fact is that we are competent to if trained properly, and the Board of Social Work Examiners have submitted testimony to you showing that the person must be trained properly to be able to do this work. I'll take any questions that you may have. If not, I would like to just go on and let you know that clinical social workers, our statute references the Health General Article 10-101, which is the physician's article. And if you look at that...
I think at this point it's going to have to be in your written testimony.
It is in written testimony.
Okay.
That is in written testimony. So...
Are there any questions from
Any
members?
questions? I'd be glad to try to answer. And the only other thing I'd like to do is thank Delegate Cardin. I've worked with his dad for many years. And
Cheap ploy, cheap ploy.
Cheap ploy. And Delegate Conway, his father of blessed memory, was
Double cheap
instrumental
ploy.
in helping us get another bill, getting the guardianship bill.
We do have opponents, so you might need to keep banking those. All right, we're going to hear from Mr. Kroll next, I believe. And do we have, there's one other online witness who might be with us. Okay.
You want us to get out?
Yes, please.
Okay.
Thank you. Mr. Kroll, when you're ready.
Mr. Vice Chair, members of the committee, good afternoon. Slowly off to good evening. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland, Executive Director of the Maryland States Attorneys Association, here in opposition asking for an unfavorable report as to House Bill 1070. Imagine Public Defender's Office and the State's Attorneys agreeing on something. Hard to believe. But last year, it is hard to believe. But last year, Mary Pizzo, P-I-Z-Z-O, Director of the Office of the Public Defender of Forensic Services, said it best when she testified during committee hearings on similar bill, exact similar bill, House Bill 1177, and she stated the following that we can agree upon. Social workers do not have the evaluation standards, training, or educational background to render opinions in such important issues such as not criminally responsible, competency, and commitment release. I agree with her 100%. Social workers do not have that background or competency to testify. Therefore, we're asking for an unfavorable report as to House Bill 1070 because social workers do a great job in aftercare. Not a good job, a great job. But for the ultimate issue, which is so important, especially in juvenile cases, especially in non-NCR cases, not criminally responsible, especially in competency, and especially when it comes to looking at important issues such as commitment release from an institution, only a psychologist and a psychiatrist can render that opinion. We ask for an unfavorable report. I'm happy to answer any questions. Thank you.
All right, next we're going to hear from Brian Zimnitsky.
Good afternoon. Is my video working?
Yeah, you're good. Keep going.
Okay. Good afternoon. My name is Brian Zimnitsky. I'm a member of the Maryland Psychiatric Society. and I am speaking on behalf of the Maryland Psychiatric Society and the Washington Psychiatric Society. We are opposed to passage of House Bill 1070. I am a forensic psychiatrist with training in a forensic fellowship program at the University School of Maryland. The evaluation of competency to stand trial, criminal responsibility are currently conducted by psychiatrists and psychologists with expertise and training in forensic psychology and psychiatry. This requires not only expertise in mental illness and diagnosis, but knowledge and training in the interactions between psychiatry and the legal system. The competency to stand trial evaluation involves diagnosis, treatment, safety assessment, the interactions of mental illness and medical conditions, as well as the potential impact in assessing an individual's understanding and ability to participate in court hearings. For criminal responsibility evaluations, it's imperative to understand the impact of medical conditions, medications, and substance abuse, and one must have training and experience in the assessment of mental status of the individual at the time of the offense. Additionally, for civil commitment, it's important to know the medical conditions and their interactions and how they impact a patient in terms of forming treatment plans and whether they should be civilly committed. I would add that social workers do not have the adequate training or experience in conducting these evaluations. Thank you.
Okay, I don't see any questions for this panel, so thank you very much. That's going to end the hearing on that bill. We are going to now move to House Bill 729, Delegate Grossman.
I can't hear you, Delegate.
I'm sorry, my bad.
You weren't here last
Got it.
time. I forgot my megaphone, too. Sorry, guys.
All right, whenever you're ready, you have 3 minutes.
Sorry. Thanks for having me back. Mr. Chair and members of the Judiciary Committee, for the record, my name is Delegate Brooke Grossman, and I'm here to present the amended HB 0729, Real Property Sheriff's Notice and Subordinate Interest for your consideration. The purpose of HB 0729 is to help address the blight issue many communities across the state of Maryland are facing. In areas like Cumberland and Frostburg, this issue is compounded by the poor economic background in those areas, and under current circumstances, it's very challenging for local governments to remedy the issue. HB 0729 seeks to refine the sheriff's sale process, thus creating a direct path for local governments to obtain title of blighted properties for remediation. At the same time, preventing borrowers from claiming exemptions during the collection of debts when sales are conducted. I will share with the committee that the cross-file of this bill, SB 0277, passed the Senate unanimously, and I will ask that the committee give a favorable report to HB 0729, and with that, I'll turn it over to my panel.
Mike, you want to go? Good afternoon. My name is Michael Cohen. I'm the city solicitor for the city of Cumberland, and I'm here to talk on behalf of the city in regard to House Bill 729. The reason that how we get here is that from time to time, municipalities will seek citations or will cite property owners for violations of their property maintenance and nuisance property codes. And when they obtain judgment, they index them in the records of the circuit court. And the judgments obviously become a lien against the real property. So as a measure of enforcing the judgment, you also have the remedy of a sheriff's sale. You can execute on the property and have the sheriff levy and sell the property. Presently, when the sheriff sells real property, it's sold subject to all liens without regard to their priority. This measure would give primacy to senior liens. With this measure, any property sold would be sold free and clear of junior liens. This won't result in the cancellation of the debts that are owed to the junior lien holders, so they will still retain those debts. However, this frees up the way for senior lien holders to push forward these sales. And the reason I say that is because from time to time, it's not uncommon actually that when properties are executed upon, that there are junior liens that have attached since your judgment or the municipality's judgment was entered. So this makes it easier to actually proceed with the sale because prospective purchasers don't want to buy lien-laden properties. As for the exemption provision, debtors are allowed to exempt a certain amount of value in property from execution, and that includes with sheriff sales. Applicable law provides that exemptions don't apply as to certain types of liens, including tax liens. And this measure would treat local government judgment liens for violations of property maintenance and nuisance condition laws the same way as taxes.
Good afternoon, Vice Chairman Moon. I'm Ray Morris. I'm the mayor of Cumberland, and I truly appreciate the opportunity to speak to you all today. You know, when I became mayor 5 years ago, what I realized was one of the biggest issues we have in the city of Cumberland is blighted properties. At that time, we had a study done, and it was 512 blighted properties in the city of Cumberland. If you extrapolate that out, that's more per capita than the last report I saw for the city of Baltimore. So this is, it's not a unique problem to Cumberland, but it is a problem that is across our state. And what this does is it gives us a tool. It gives us a tool to be able to try to stop the blighted properties. A lot of times with these, if we were able to get a hold of them before they have to be demolished, quite frankly, a lot of these are going to have to be demolished. I'll be quite honest about that. But if we can get to them before that state, it's really a good thing for us to be able to do. As you all know, a property that is a blighted property on any street, on any community in our state, is bringing down the property values of that location, and it's also making it a neighborhood in which people don't want to live. And quite frankly, that's something that we're working to do, is to revitalize our communities in Cumberland. So I truly would appreciate your support on House Bill 729.
Okay, thank you very much. I don't see any questions. Oh, wait, all right, Delegate Kaufman.
Yeah, Mr. C, if I don't wave my hand. But anyway, Delegate Grossman, do you believe that, first of all, I commend you for getting bipartisan co-sponsorship on your bill, because the minority leader is a co-sponsor of this legislation, as is Delegate Heinbaugh. But are you at all concerned that this process will lead to more people losing their homes, or are these properties such, the way I read the bill, I just want to make sure it's right, these are properties that are already abandoned. I just want to make sure I read it right.
Thank you for your question, Delegate. These are properties that are already abandoned, right? These are blighted, sometimes properties that our municipalities are looking at having to tear down, but don't have the ability right now, right, to take ownership or possession of the property to be able to do that. This is in no way meant to lead to individuals losing their homes, and they're not owner-occupied units.
That's what I thought, but I just wanted to clarify. Thank you, Mr. Chair.
Thank you,
Delegate Grossman.
All right, I don't see any other questions, and there's no one to speak, signed up to speak against the bill, so thank you very much.
Thank you.
Thank you.
All right, we're going to move on to House Bill 986. Do we have Delegate Hill here? Okay. Oh, there she is.
Yeah, I'm here. The panelists are here or not.
This is joint with Ways and Means. We have our friends Marika North, Hornberger, and Grossman.
Please.
Yeah, if you wouldn't mind, she's actually in for this hearing.
No, you're with me. There aren't many of us. Okay.
Let's give a second for Delegate Grossman to get back in here. Okay, great. And is it just the two of you on the favorable panel?
I believe so. I thought that someone else would be here.
Yeah, it looks like I've got Margaret, Han, and you.
Yeah.
Okay.
I thought Meredith might be here. Yeah, but I guess she didn't make it. Okay. All right. Thank you, Mr. Chair and members of the committee. My name is Terry Hill, and I'm presenting House Bill 986, Maryland Real Property Transfer on Death Act. So just a little background. Back in 2020, Attorney General Brian Frost created the 2020 COVID-19 Access to Justice Task Force. And one of the subcommittees on that task force was the Life and Health Planning group. And the purpose and the goal was to look at, particularly in the context of COVID-19, what are the things that are preventing Marylanders from having equal access to the law and to all that goes with that. One of the things that the Life and Health Planning identified was that for a small group of Marylanders, particularly a group of people who with very limited means, and primarily those for whom the home is the only real thing of value that they have, the lack of a transfer on death statutory deed option meant that they were losing out on the opportunity to pass real estate property from one generation to the next. And we wanted to look at what might be done for that. At that time, we found out that the bar had been looking at this issue for some time. The elder law and estates and trust and real property sections have been going back and forth about the current tools that are available and whether a transfer on death deed, particularly following the Uniform Code model that has been enacted in over 30 states, would serve a purpose here in Maryland. And because they have been struggling with it, we came back in 2021 with a bill asking for a task force to look at it and decide once and for all whether that was the right instrument here in Maryland. The bill was introduced in the Environment and Transportation Committee, and the chairman at that time said, if 30-some states are doing it, we don't need a task force. Come back with legislation creating a bill that creates this thing. Let's just get it done. So Senator Eckert and I, that starting in 2021, formed a task force of over 35 different stakeholders, and we worked hard on first evaluating what was done in all the other states, determining whether this was a tool that would be of benefit, even if only to a small number of Marylanders, and coming up with legislation which was introduced last year. And there was some resistance from essentially the same groups who are resistant this year, although they did participate and we took many of their amendments. But we're back again because we believe that a transfer on death statutory document does have a role. It's not going to be for everybody. It's probably not going to be for the vast majority of people. But we do believe that there is a group of folks here in Maryland who are not having access to generational wealth transfer that the rest of us have, and we believe this would serve their purposes. That being said, I've given you a lot of information that you should have received, including the ERPTOTA documents as well as the rationale, and we're open to additional amendments, but what we've gotten in the last month is just, that this is not something that they think we should do, and we don't have any other suggestions for how to fix it. Thank you.
Good afternoon, Vice Chair and members of the committee. My name is Margaret Henn, Deputy Director at Maryland Volunteer Lawyers Service. I also participated in the task force that Delegate Hill mentioned, where we had many meetings over the course of the year, and as she mentioned, sought input from many different stakeholders in this, including the court system, including title insurers. For Maryland Volunteer Lawyers Service, we work with that group that Delegate Hill was mentioning that this bill would benefit. We have an advanced planning project that is designed to stabilize neighborhoods, preserve family assets, and reduce the number of properties in Maryland that have deed and title entanglements that also, lead to vacancy. Something we frequently suggest to our clients is a life estate deed, which allows a property to pass automatically upon someone's death without the costs and the legal hurdles that are involved in the probate process. But one of the primary barriers we see to families doing advanced planning and transferring properties from one generation to the next is the cost associated with getting a lawyer, or not even knowing where to find a pro bono lawyer. And we know that most lower income people do not have lawyers. For civil cases, 80% of people who are low income are not represented in their civil legal cases. The transfer on death deed that's proposed in this legislation would address this issue. It would provide a clear statutory form document that could be utilized by families without the need for a lawyer. Would this be, as myself a lawyer, would I love for everyone to still get legal advice? Yes, but we know that that's not the reality, that's not obtainable, and it doesn't happen. So for this reason, we need to empower communities, particularly low-income communities and communities of color, with the tools that they need to do advanced planning. So I respectfully request a favorable report on this bill.
Questions for the panel? Delegate Conaway, then Delegate Phillips.
Thank you, Mr. Chairman. Thank you, delegate and witness, for coming in. In reference to this property that's going to be transferred, is this property mortgage-free, or it doesn't matter if it has a mortgage on it?
Do you want to answer?
It doesn't matter. So essentially, what happens is the person who would inherit it would carry on the same obligations as the person who died.
Okay. And the mortgage company would have to accept the document that would be issued, the standard document?
Well, I mean, the document that would be recorded would be a deed, as with any other deed. So, it's kind of similar to a life estate deed that I mentioned, which is already something that we have here in the state of Maryland. A mortgage company is under no obligation to let someone record a life estate deed. That oftentimes they do, but our clients that are getting that kind of deed often approach their mortgage companies before transferring title, and I would imagine that that would be the same thing that could happen with these transfer on death deeds.
What you used the phrase "let someone transfer the deed," but
I think I meant assume the mortgage. Let the new party assume the mortgage is probably, I should have used that terminology.
Okay. But it's possible that the mortgage company might not accept the deed if it wasn't recorded, let's say at the Register of Wills office or something like that?
It's not that they wouldn't accept it, but they typically under a mortgage have the right to accelerate the mortgage and make the entire mortgage due and payable when a deed transfers. So what a client might be asking to do in this situation is to not have them accelerate the mortgage when the deed transfers and to let that person become the new person who would be responsible for paying the mortgage.
If I may add, Delegate, we have currently, without this, and with people not having tools that they find accessible, situations where you may have, for instance, someone who's elderly and a family member comes home to help them. They see that there are bills. They start paying those bills out of their own money.
Sure.
Often with the assumption that when that person dies, they're going to get the house. And what ends up happening is without a tool, they don't.
Right. Well,
And it passes outside, and but the mortgage company accepted those payments even though they were on someone else's behalf.
Sure. Delegate, I'm sure that you're aware that we've been discussing having forms, estate forms that don't have to go to the Register of Wills, but when a person becomes deceased, they might not be, the standard document might not be accepted, and they were talking about some of the documents that you can get off the line and fill them out. So some places will accept them, some places won't accept them. That's why I was asking the question. But I thank you very much for your answer.
Delegate Phillips, then Delegate Tolles, then Delegate Carton.
I want to make sure, I think that, and maybe you can tell me if I'm wrong, and I don't see where this addresses it. Currently, there is a requirement that under Maryland law that requires a deed to be prepared by an attorney. Does this specifically take that away?
Correct. For this particular product, a transfer on death deed, yes.
Okay. And so I'm not sure, and I haven't looked at all of the testimony. When it comes to title insurance and things of that nature, have they weighed in on this at all?
Yes, I think that that is in the written testimony. I do think that they have concerns about it. And, you know, like I said in my testimony as an attorney, I would love for everyone to get legal advice, but we know for many people they can't afford that or they will not seek it out. And so we feel like this is the better option, but I don't dispute that there are some concerns with not getting legal advice before doing a deed.
Yeah. No, I like this bill because I think we need to make it easier, particularly in the African American community, for people to save their properties and maintain their properties within their family. But I am a little concerned because we have a pretty intricate set of laws around property rights, and passage of property from one party to another. It gets a little complicated.
Yeah, so let me just
then,
add.
yeah, there are other factors besides just kind of doing this. The mortgage question.
So some of the things that we did, just so that you're aware, the clerks, for instance, raised concern about how they would know or how anyone would know who was named. So one of the things that we did do is require that there be some description of the relationship, right? So John Smith the dad or John Smith the son, right? So we asked for there to be a question about the relationship. What the title insurers have asked is, why is the mailing address optional? Well, the mailing address is optional because someone may know that they want to pass it on to John Smith, and they know it's their nephew, and they're not quite sure where, and that would mean they couldn't name that person. The other thing that we did is we made this, unlike in other states, we tried to make this very narrow. So it has to be a property that is owned by one person, no joint tenancy. It can only be passed on to one person, so no share. And we thought that it would be important that if the bill passed, that we would ask the chairs of each committee to request that the bar do a look back in 3 to 5 years to say, how is this working? Are there problems with it that we need to fix? And is it working well enough that we can expand it to include more people? So this is really almost like a pilot study of something that we think is really important, because there is a group of people who do not have access to the tools that the state offers, even though they may be better tools to use.
I would also add that this doesn't circumvent all of the regular rules for any other deed in the state of Maryland. Most everything that applies to any deed you would record applies to these transfer on death deeds. I would say the main difference is not having to have an attorney to do that.
Thank you, Mr. Chair. I think I'm answering my own question. That's in my head. I haven't gotten out yet. But would you agree, or isn't it so, that individuals that are already, say, a parent, dies and their child is also on the deed, then this bill would not apply to them, because once the parent dies, the property automatically goes to the second person on the deed. Or is it?
Yes, if the person is already on the deed, this would not apply to them. This applies to situations where you're trying to add, a child or an heir to the deed to take ownership after you die.
After no one, I guess I'm saying if the person is on the deed, then the parent on the deed, they pass away and no one else is on the deed, then this is what this bill is attempting to assist those individuals.
Well, you can't access one of these after the person's died, though. You'd have to do it as part of your advanced planning. So the parent would have to execute this deed while they are living, naming the child who would, take over the ownership upon their death.
Okay, I have some, I guess some further clarifications, but I will speak with Delegate Hill Hill offline, because I'm not sure if you are doing, I think some of the problems we see, particularly with, certain levels of income, lower level income, they may not do advanced planning.
Right.
Yes.
And so there is sort of that disconnect there in ensuring that if they don't have the wherewithal to know how to go about that.
Right. So, and let me, you're also getting to, so there's an education piece, and it's interesting to me that one of the things that the opposition says is that we're asking judicial administrative offices to come up with documents that explain to people, this is what, if you're going to use this document, be concerned about these issues, here are some alternatives that you may want to consider, and this is what you have to do. They argue that it's in a way asking them to provide legal advice, and that's not what they do. What's interesting is that when we first did the initial drafts, we had very prescriptive language about what should be given to the public so they would know whether this is the right option to them or whether they should look for legal advice and what that would look like. And we were told that's too prescriptive. We write these things all the time. Don't tell us how to give the information out. So we've given sort of minimal outline of what the information might look like as a suggestion. And we're leaving it up to the administrative offices to not only determine what that language should be, but how those documents or online forms should be made available so that the public saying, I'm saying, gee, I'd really like to pass this on to my niece. I don't know how to do that. And call a lawyer and you can't get there and you say, gee, I wish there were a way I could just fill out a form and do this. And then you could look and see that there's a form and here's some instructions about what you need to know, including where you find the legal name or description of the property so that what you're describing can actually be identified and passed on.
Okay, thank you. Mr. Chair, real quick, a quick comment. I see where you have the Clerks Association here, but the Registrars of Wills don't see where they provided testimony. So I would, like to see where they are on this bill because they're the ones that have those discussions.
Right. So the Register of Wills were part of this, and they said that this shouldn't come to them at all. So they were the ones that said, these documents don't come to us. This is outside of probate. And there are members of the Register of Wills who are in support of this as a tool. I don't know if they took a final vote on it, but we can certainly touch base if that will make a difference. But this is not going to be filed with the Registers of Wills. And they were very clear that because of the nature of this, this is not where this goes.
Interesting. I see it. Okay, we can talk offline. I thought they would be based on some of the work I do with the Register of Wills and Prince George's, but we can talk offline. Thank you, Mr. Chair.
Thank you, Mr. Chair. I'll just ask a couple because I have a lot we can maybe go back afterwards. Thank you for bringing the bill, Delegate Hill. First of all, this isn't an intent to avoid inheritance tax, right? They would still be required to pay the inheritance tax, right?
Correct.
Okay. Number two, if a mortgage company, they use like personal information and specific financial backgrounds to determine interest rates and other issues, and would the mortgage company be able to go back and reassess whether they want to offer the same rate or change it?
So I don't think that this bill would change the terms of the mortgage because the mortgage is typically a contract between the mortgage company and the individual who took out the mortgage, right? So the mortgage typically both attaches to a property and attaches to and the person is personally liable as well. And so I believe when the person passes away, we've set it up that the mortgage continues to be a lien on that property, but I think that the mortgage company would have to be allowed to determine whether that heir would be able to personally assume the mortgage or not.
So that opens up, you don't realize how many questions open up. So let's say the person who's been assigned this deed, now they say, well, that person, there's no way that person can pay, $2,300 a month, right? So they have a lien and they want to act on that, or there could be another company, there could be lots of people that have liens on it, and they're concerned about how much risk is being created by something that they had no say in when they originally set up this instrument. They knew exactly what the parameters were, and it's being changed without their consent.
I think if they have a lien and the person is not making the mortgage payments, they still have the option to foreclose on that property.
Absolutely.
Right, except that the terms that they created were based on the person they made it with, not with this new person they were getting. I'm just concerned that we have to think about, we can think about this later. And then the last thing is, if there's a conflict with a will, where is this, are we actually trying to reduce the amount of litigation or potentially creating open holes for more litigation if this is deeded to somebody, let's say a non-family member, maybe a healthcare, a person who's providing healthcare, and there could be allegations of undue coercion or influence, and there may not be, but there might be. And so therefore, we're opening up for litigation because the family is saying, wait a minute, this is a $250,000 house that this person just got title to, and we all knew that in the will, she gave it to us. But, I'm just...
So, I mean, both the undue influence question and the mortgage questions you were mentioning were brought up in some of the discussions that we had in this task force. It would be something that would pass outside of probate. So it would not be, under the will. Just like a life estate deed. A life estate deed passes automatically outside of probate, and that property isn't part of the person's estate.
Right. So, and I can just see now the potential fraud type litigation that would have to happen that would then bring this possibly into a probate, which could cause all kinds of weird things. We think things we need to think about as we talk about this bill. Thank you.
That was brought up, yeah.
Ironically enough, Delegate Cardin kind of asked some of my questions, which was the question about the probate, because that was one of my questions, whether or not this would be subject to probate.
No.
But you said it would pass outside of probate. And so in your testimony, you said it would operate more like a life estate. And I guess my question mark that I have is, I think what Delegate Tolles was trying to capture was, I guess you're promoting this in an effort to try to capture individuals who do not do advanced estate planning. Mm-hmm. But in order to do this, the individual would have to think about what is going to happen to me when I die, which is estate planning. And so I guess, and I understand, yes, everybody can't afford a lawyer. I get that piece. We want to make it easier for those who don't have the means to hire a lawyer to be able to get sound advice about how to proceed forward with their various options. And I know there's an education component to this bill, but I guess my question concern is with the education component with this bill, are they going to get all of the things that they probably should get if they talk to a lawyer? Like, my question is, if I decide to use this option, how is this going to affect the taxation of my heir who is going to inherit this property? What is going to be their adjusted basis when they inherit this property if I use this method? Like, that person needs to be aware how that's going to affect themselves financially.
Right.
And so when you do advanced estate planning, you go over all of those things with the individual. And so that's my worry that I have.
Right. So I think that that's the worry that all of us have. But the reality is that there are a group of people who aren't going to get that advice, who aren't going to ask those questions, and who right now don't have a tool to use at all. And when they die, their property goes to the state. And so we're not trying to tell people that this is the best option, right? It's not the best option. And in fact, even in the language that we put in there, it says you may still want to consult with a lawyer. This is not a great option. But what we're saying is the reality of what people have is that they either do the other options, the trust, the life estate deed with or without,
Right.
right? They go through the will, they go through all those things, but there are people who aren't doing anything and feel as if they have no option. And what we're hearing from our opposition is, we don't want to give them one because it's not the best one available.
But
And
couldn't
what
they
we're
just-
saying is that it may not be the best, but at least it's a way for them to try and do the thing that they want to do.
Right. But couldn't they also just do a quick claim deed, which in theory, yes, you should have an attorney to help you even do that. But I've seen a lot of people do quick claim deeds without the assistance of an attorney.
Well, if you do a quick claim deed, then the person who becomes the owner of the property becomes the owner of the property right then and there. And if you're
Right.
still living, they have a lot of control over your property, you know, the home that you're potentially living in. Like, they could take out loans on it, they could sell it from under you. Just doing.
Oh, I'm not saying it's a great option. I'm just saying I see that a lot, especially in poor communities and individuals. They're like, I know I'm about to die. I'm going to do this quick claim deed to give this property really quickly to my daughter or whomever right before I die, and I'm done. I've seen that.
It's an option that we almost always advise against because it has so many risks with it, doing something like that.
Right. And I guess my other question is the notice piece, if someone were to exercise this option that you're proposing. Because I think this is what Delegate Cardin was trying to get to as well. So I have this document sitting around. I say I want this property to go to my daughter, and then I die. It's not recorded in land records. No one has any actual notice.
It doesn't go into, it is not, it's not, you have to actually file it.
You do have to record it in land records.
You do have to record it.
Right.
Just
Oh,
like
okay.
another
It doesn't count if you don't. So you
Right.
can't just find it in someone's house. It has no effect.
Right, just like, that's like where it comes into like.
So
just
it's like a life
requirements
estate
of any
deed
other
then.
deed. Yes, yeah, you have to.
So it is
record
recorded. It's like a life estate deed. I own the property, but upon termination of my life, it automatically gets transferred to X.
Correct, correct, yes.
But then why not just do a life estate deed?
Well, because you need an attorney to do a life estate deed, and we know a lot of these communities are not going to access an attorney.
All right, I'm done. Those are.
519. Delegate Mariku North, then we're going to Delegate Taylor, then Delegate Simpson.
I will be brief. Thank you, Mr. Chair, and thank you, Delegate, for this bill. Being from the Ways and Means Committee, my question was leaning towards the revenues discussion. I'm looking at the fiscal and policy note, and it specifically says that this is going to reduce probate fee and inheritance tax revenues collected by the Register of Wills. Your response to Delegate Toll's question kind of piqued my interest in this note because you mentioned something about the Register of Wills not getting involved. So I just want to clarify, how do you see the Register of Wills being impacted by this? And is the result of, if this bill became a law, how would this impact the Register of Wills, and will its impact outweigh the purpose of this bill?
So I don't think the comparison, which they've done here, is between if you do a will versus you do this. It's really about if you do nothing versus you do this. And I think that's the disconnect here. So that's why the Register of Wills are saying, if it's outside of probate, this doesn't affect us at all.
Well, I've been told by the Register of Wills in the past, not related to this bill, that small estates are less than 1% of their revenue, and I'm assuming that most of these would, if they were going to go through the Register of Wills, would be small estates, because we're talking again about like low-income people where their house is their only asset and they don't really have any other means. So I don't think it would be significant, but I would defer to what the Register of Wills says as far as the dollar amount.
And I would just add to that we've actually had several bills that we've passed in the last 5 years where the Registers of Wills are looking to eliminate the fees on these small estates because they don't add up to much, and they think that they're sort of punitive for people who don't have much money.
I appreciate that, because the fiscal note also mentioned, that their salaries are going, are paid through these fees. And I thought, well, geez, how much money we're really talking about to deal with the
And
salaries?
if it helps you, like I said, it's all going to ask for us to touch base with the Register of Wills, and I can certainly get information from them if there's a specific question.
Delegate Taylor, then Simpson, then Tomlinson, then Conway, then we're stopping.
Mr. Chair, my questions have been asked and answered. Thank you.
I definitely appreciate what you're trying to do. I really wish isn't there has to be an easier way to do this. I mean, now the MVA came up with a way that we could all gift our cars if something were to happen to us. You know, isn't it possible that we can come up with an easier way to gift our homes or other kinds of things? Then, I mean, I get that that's what you're trying to do.
Yeah, I don't think this is complicated, right? It's, you take a form, you find the legal description of the property, which can be tricky, but you find the legal description of the property, you get the witnesses, you get it notarized, and you name the person who you'd like the property to go to when you die. You take it down to the courthouse, and you file the paper along with, what's the form card that they have to turn in? There's a form they have to.
The intake
They
sheet
fill out the intake sheet.
that you do for any deed.
Right, and
Yeah.
that's it.
Yeah.
That's as simple as it gets.
Kind of wish it could be just done with the deed itself, you know? It'd be easier, but I get it. It definitely needs to be easier than having to hire an attorney. So, thank you.
Just file it, and that's as easy as it is?
That's it.
Oh,
With the
okay.
intake
So
sheet,
there's no
you have to
money,
fill out the
there's no
intake
money
sheet.
involved to file it?
They're just like any other deed, the courts have a fee to record a deed.
One person was going to say no, I think, and you're saying now yes, but it was left out of the description. Is that correct?
Well, it's
It's yes or no?
the elements of the real property code
Right.
apply to this deed.
And
just
so
like any
in
other.
Baltimore, when we're talking about small estates, how many small estates come through the Register of Wills office every year in Baltimore? And do you know what the impact will be in Baltimore for the Register of Wills office?
I don't have that number in front of me, but I could get
You
that
said
to
it was a very small number, less than 1%, I believe. Did you say?
Less than 1% of revenues.
Of
I don't think
revenue.
it's less than
Does-
1% of the estates, but less than 1% of revenue.
And you think that would still be accurate for Baltimore City?
That was what I was told for a statewide number. I don't know what the
statewide.
number is for the city, but we could certainly ask that.
Yes, I would appreciate if you asked the Register of Wills and the Clerk of Court. Thank you very
And
much.
can I just ask for
Sure.
clarification? Are you asking for as a percent of the revenue or as the number of estates that they deal with, which, or both?
Well, in the description, at first, when you were describing the bill, it was just take the paperwork down and file it, I think, with land records, and that's as simple as it is. And therefore, the Register of Wills office would potentially lose money. But I was looking at this testimony on the unfavorable from the clerks of the courts from another jurisdiction, Washington County, and they were against it, and I didn't see any testimony from the Baltimore City Clerk of the Court. So I'm wondering how we're transferring these deeds and how we're doing all this paperwork, and there's no money being transferred. Then I hear there's money being transferred for less than 1%, and I need to know what the effect is going to be in Baltimore City. I think it's reasonable for me to ask that since I am from Baltimore City.
So the cost of recording a deed in the land records office statewide is where there's no money being transferred hand, it's typically $60.
Oh, that
So
might make a big difference for Baltimore City's budget, but I thank you very much. Thank you.
Seeing no more questions for this panel, we thank you all very much, and now we'll hear from those people who are opposed. We hear from Jeffrey Thompson, Sharon Burke, Kevin Tucker, Dawn Lindsay. Who'd like to go first?
I suppose I will.
Go ahead.
Mr. Chair and honorable members of the committee, I'm Jeffrey Thompson. I'm an underwriting counsel for a national title insurer, actually the Mid-Atlantic Underwriting Council, and a past president of the Maryland Land Title Association. I'd like to refer you to the MLTA's written position on this bill and respectfully request that this committee return an unfavorable report for House Bill 986. Unlike states that have already needed to enact the transfer on death deed legislation, Maryland already has a type of deed that is a life estate with powers that does exactly what the transfer on death deed does and has been doing it for generations for everyone, not just a small segment of the population. And while the bill's intent to create a form deed that can be used without an attorney is noble, I can tell you as an underwriter, what the language of the statute requires is that the person have one child. And if that person doesn't have one child, that person has to choose a child and hope that that child is willing to share. Because if they look at a blank form deed that's put in front of them and they put in multiple names, then there's a question as to whether the statute works and whether the title has effectively been transferred and whether it can be insured. And as a title insurer and the person who's been called upon to determine the insurability of situations where either individuals who are expecting property have been excluded or where people have filled out a form with very little information on how to fill the form out and what needs to go into it, I can tell you that quite often the result is complicated, it is expensive, it requires legal intervention, and far more than the attorney's fees that this bill seeks to do away with. So we request that you return an unfavorable report, and I'm happy to answer any questions about conveyancing, about the mortgages, about title. I've been at this for about 40 years.
Thank you. Please.
Good afternoon, Mr. Chairman and members of the committee. My name is Sharon Burke, and I'm the Senior Manager for the Non-Case Division for the Clerk of the Circuit Court for Anne Arundel County. I'm here today to support Clerk Lindsay and Clerk Tucker to answer any questions you may have and to ask for an unfavorable report for House Bill 986. Thank you.
Thank you, Chair Clippinger and members of the committee for this opportunity to testify regarding House Bill 986. My name is Kevin Tucker. I'm the Clerk of Court for the Circuit Court for Washington County and President of the Maryland Circuit Court Clerks Association. My testimony today is on behalf of the Clerks Association. The Clerks of the Circuit Court asked for an unfavorable report on this bill because even though the sponsor has worked to try to strengthen our previously identified issues with this bill, we still have several questions and concerns regarding the potential impact on members of the public who may attempt to use the TOD to transfer property. These questions include, as related to real property 3104A2, Section 2, it indicates that the ownership of a property that is subject of the transfer on death deed may be transferred on the assessment records to the designated beneficiary only following the death of the transferor named on the transfer of death deed. How will the assessment records and the land records offices know when a transferor's death has occurred? Is the beneficiary going to be responsible for notifying the assessment office upon the passing of the transfer? How is this going to happen? How will the beneficiary know that they are responsible for notifying the assessment office? What happens if they don't make the notification and the mistake is not discovered until many years later? Who is going to ascertain that there is not a revocation on the TOD filed? Second question is related to real property 14806B. Indicates that a TOD is effective without notice or delivery to or acceptance of the beneficiary. How will a beneficiary be made aware that they've been named on a TOD deed? How will they obtain title insurance on a property that they have been notified about? And what happens if they don't accept the property or they disclaim it? These are several of the questions that we have. I know I'm running short on time. I appreciate you allowing me to speak today. I'll answer any questions that you have and do ask that you submit an unfavorable report. Thank you.
Hi, I'm Dawn Lindsay. I'm a clerk of court for Allegheny County, and I'm here on behalf of the Maryland Circuit Court Clerks Association. We asked for an unfavorable report on this bill last year, and we again asked for that. I just want to clear up, make sure the committee's aware of a couple things. One, you do not have to have an attorney to prepare any deed in Maryland. Anybody can prepare their own deed. So that simplifies one process. Another thing is it can be given to anybody. So I have a friend named John Smith. My dad literally is actually a John Smith. If I put that on there and there's no other information, how's anybody going to figure out what John Smith I want this property to go to? The bill does not require a LIBOR and folio on it. So I own multiple properties. How are they going to know what property they are inheriting if it doesn't at least require the LIBOR and folio to be on there? And again, Mr. Smith has no clue that I'm going to give him this property upon my death, and then he finds out perhaps once the property goes in a tax sale, once they do a title search on it and says, oh, by the way, you owe the back taxes, there's a $500,000 mortgage on it, you're responsible for all this. So not only is the new owner unaware that they now own the property, but now they have this mental and financial burden that they may not be prepared for and they possibly cannot handle at all. Also, if I have a will that I left my property to my kids, and then on the transfer of death, I did one of these to Mr. Smith, that's going to out-trump my will, and my kids are going to be like, hey, why didn't I get the property, causing a lot of hardship and emotional stress on my family. The intention of this bill by Delegate Hill is meant to make it easier to transfer real property. However, this legislation will cause unintended hardship on families. As the recorder of deeds, the clerks have seen how a poorly written deed can be a challenge to clear up. We are always looking out for the best interests of our citizens we serve, and we feel any transfer of death deed legislation that may pass would make more sense to be kept at the Register of Wills rather than the clerk's office. The Circuit Court clerks ask for an unfavorable report on House Bill 986. Thank you.
Delegate Phillips, let's begin.
Mr. Chair, please indulge me. I'm sorry, I don't usually keep going. I'm practicing. But this one, I understand the intent of Delegate Hill's bill, and I actually really like what we are attempting to do. So I'm trying to figure out how do we accomplish this in our current format. And let me ask this way, because I know you talked about, who would know, how do you know? When I do a life estate deed today, it's very similar to what we're discussing here. And so the parties don't necessarily know that they've been named. The children don't know, right, when I do the life estate deed. So how does that differ? And help me figure out how do we help Dr. Hill get this done?
I believe that once the bill goes on, or once the deed goes on record, it is public notice. And you're right, whether you are named in a life estate deed or whether you're named in a transfer on death deed, you still have the same issues with respect to does this person know whether or not they've been named. But once again, I point out that's why we already have something, and we have generations of judicial interpretation of the life estate deed with power of alienation. And I don't know if anyone needs an explanation, but a life estate deed says that I'm going to give the property to you, and I'm going to reserve the right to live in the property as my own while I'm alive. What happens when I do that is you now have a say in what happens because you are partially the owners of the property. Maryland is different from other states because Maryland has a life estate deed with a power of alienation. That means that I can say, hey, I'm going to give the property to you. I'm going to reserve the right to live in it by myself. And you know something? If I wake up tomorrow and I don't like you anymore, then I can go ahead and mortgage or deed the property to somebody else without your consent. That's what a transfer on death deed does. And that's why other states that don't have a life estate with powers of alienation had to enact transfer on death deed legislation. They didn't have that right. The main emphasis of this bill is that form deed. And by the way, if there is a mortgage and I'm the child and my father has a mortgage on the property, I'm no good. If you look, I've got a credit report that's, terrible, and I've got creditors out the wazoo. But I believe there's a federal law out there, the Garmain-St. Germain Act, which basically says that the lender can't accelerate the mortgage. So that takes care of that issue about, what happens if they call the mortgage. Now, they can still foreclose if I don't make the payments, but it won't affect the lender in that fashion. And have I addressed that? Or
Well, you haven't addressed that.
The issue is, how do we go about making this available? And I will tell you.
To simplify it so that an individual right? Does not have to go through the process of going to a lawyer, of doing a life estate deed, of trying to figure all of that out.
And I'll tell you that that's one of the harder aspects of my job. Because right now, if I need a deed and I need a form of a deed, all I have to do is Google form deed. And up pops a deed that works wonderfully in the state of Illinois. But I haven't the foggiest idea whether it works in Maryland or not. And it is my job often at the 11th hour when people are either trying to sell or they're trying to refinance, to have to come in and say, well, you filled out the wrong lines because you didn't understand tenancy, you didn't understand, real property concepts, and therefore you don't really have the property and you need to go to court to get it cleared up. That's far more expensive than the cost that it would take to go and sit down with a lawyer and straighten it out. And it happens at the worst time. It happens just when these people desperately either need to refinance to prevent a foreclosure or when they're trying to sell to prevent a foreclosure. And unfortunately, from an insurance standpoint, I can't insure that because what they've put on is a defective deed. And most people, I'm just as guilty as everybody, they don't read instructions. They sit down with a form, the form has a line that you have to fill in, and they put in 7 or 8 children because they have 7 or 8 children. And that now takes it outside the scope of the statute. And there's a question as to whether that then affects the transfer of title that the bill is trying to achieve. I don't know that there is an answer to can we provide somebody with a simple form, because real estate is not simple.
Thank you.
Further questions for this panel? No? All right, thank you all very much. That concludes the testimony on House Bill 986. We thank you all very much, and we thank the people from the Ways and Means Committee for joining us this evening. All right, thank you. We're now going, I think, to Delegate Queen. See that? Delegate Queen, 704. Who do you have?
I don't know if I have a panel. I don't think so.
Do you have anyone to testify? Okay, that's fine. So we'll hear from you and then from those people in opposition. Go ahead, Delegate Queen.
Thank you, Mr. Chair Clippinger and members of the Judiciary Committee. For the record, I'm Delegate Pam Queen, presenting HB 704, Firearms Tracking Technology Bill. And so I want to say, after serving 3 sessions on this committee, I really commend the work you do and the long hours you put in. I do remember that. And I'm sure you may have received some emails about this bill. If you haven't been checking your email. But I want to talk about what this bill is and what it isn't. But this is a very simple bill that's aiding with the inventory management of tracking owners of bulk gun inventory to quickly recover stolen and lost merchandise before these guns are used in a crime. And so every year we have hundreds of thousands of guns that are lost or stolen in the U.S. at a rate of 1 gun stolen every 2 minutes. According to the FBI, over a 6-year period, there was a loss of inventory of guns worth $829 million, representing $1.8 million in guns. And so one of the things we do know is that we find that with multiple gun sales, or what we call bulk sales, they tend to be 64% more likely to be used in crimes versus guns that are sold individually. And so we know that even in Maryland, that you passed some very strict gun laws recently. You just passed a law to strengthen the security for licensed firearm dealers in our state, but that still has not deterred the lost and stolen guns that we find on our streets. And so what this bill is doing is to use proven technology, radio frequency technology that's been around for years, to be able to track guns inventory easily and to be able to find these guns quickly once they hit the streets. And so we're asking you to have some videos to show you about this technology. It's used in various industries, but it is a way to make sure that we can cover guns quickly and efficiently. It does not violate any of our federal laws. It does not create a gun registry. It is only maintaining the serial number of the gun and the security tag for the using the RFID tag. And so we hope that this will help to deter gun purchases, guns being stolen, and to make sure we can keep these guns off the street. This is targeted to bulk sale users, law enforcement agencies, the federally firearm licensed dealers, shooting ranges, and other individuals and businesses that are in the business of renting and transferring guns. So we seek a favorable recommendation on this bill. Thank you.
Are there questions for the delegate? Delegate Young.
Thank you, Mr. Chair. You said that 64%, the bulk sales are 64% more likely to be used in crimes. Would you mind just sending that over? I would really appreciate looking at it. Thank you, Mr. Chair.
Any other questions? Delegate Grammer.
Thank you, Mr. Chair. So I have a concern in regard to this. So if you could make these firearms detectable, any law enforcement officer who had some kind of capacity to detect these RFID chips, anytime they saw one, they would have probable cause to stop any person in proximity. Knowing the issues with possession and cops being involved more so than they should be, isn't there a concern, frankly, with just a kind of over-policing scenario here if you could just walk down the street and have probable cause to stop anybody for any reason?
Well, you wouldn't have probable cause. So let's talk about how things are done now. So if we currently have a database where the ATF maintains a database of all of our guns, right? So what happens now when we find a gun that's been used in a crime, the law enforcement agency provides that serial number to ATF, and they can track to them what manufacturer, they have a chain of custody, they can track what manufacturer sent that gun to a particular dealer. So you would be tracking, and then they go manually to try to figure out, where might that gun be. With the tag, they would send the serial number with the associated tag. So you're only looking for the guns that we know that have been stolen. You're not doing a random search or stopping people with this idea of probable cause. You would have to know what the RFID tag you're looking for, the ID serial number you're looking for. So it's not just seeking anybody.
But if they suspected a person of illegal possession, I mean, it doesn't necessarily have to be about the gun. Cops stop people all the time for any reason.
Yeah, but I'm talking about tracking a lost gun. I'm not talking about other probable cause that a law enforcement person might stop someone. I'm talking about if you have a stolen weapon, which has to be reported, right? Your firearm, FFLs have to report their lost and stolen inventory. We would then have not just a serial number, which we do now, we would also have that associated RFID tag to go find that gun.
When police use stingrays, they don't just grab the communications from the people they're looking at, they grab everything.
Yeah, but we're not talking about stingrays to use this. We're talking specifically a technology that's been used by the military, by retailers to find lost merchandise.
Okay, thank you.
You're welcome.
Thank you, delegate, for coming to bring this bill. I just want to be clear. Are we talking about firearms that are stolen from a store or from private owners or from both?
We are talking about firearms that are stolen from stores and bulk, from stores, basically, retailers.
Okay, so after the firearm leaves the store, will the store remove what kind of chip did you call it?
The RFID tag, they wouldn't necessarily remove that tag. It would be more analogous to, you think about when you have your car and your navigation, right? And that car has tracking information in it. And so while it's in the dealer, we're keeping track of that car because we don't want, that car lost from the lot. Once you take that car home, you have to buy some service like OnStar or something to keep that tracking system going on. So the tracking system is still there, but nobody's, monitoring
yes,
it.
I think that you're accurate, and I appreciate your bill. And also, if
Yeah, I'm very accurate, but that's okay.
Oh, okay. Well, you weren't accurate in saying if you miss 4 months worth of payments, they can cut it on and find out where that vehicle is.
Well, they can
and
do
then
that
send a
right now.
repo
They
truck.
can.
Well, you forgot to say that.
I didn't talk about the repro people.
That makes it not very accurate. So therefore, a person who goes to purchase a firearm might say, well, did they take this chip out the firearm? And then suppose if someone reports the firearm stolen, but it's not their firearm, and you're
No.
riding down the street.
Now, how are they going to report that that's not their firearm? The firearm serial number and chip are intertwined now.
Right. So the person is riding down the street with the firearm, and the chip has been activated. That could happen, right?
The chip is okay. The chip is there. Go ahead.
So how do you get the chip out the firearm? Suppose
You're
if
not
you
going to
say-
take it out the firearm.
Suppose you say, I don't want the chip in the firearm.
At this point, if you're buying a firearm, again, that's why I said it's analogous to the car. And you don't take your navigation out your car
Well,
after you take.
Sure you do. Sure you do.
Well, if you can do that, then you go ahead and do it.
Okay. Thank you very much.
Uh-huh.
Seeing no further questions, we thank you very, oh wait, who did I miss? Oh, I'm so sorry, Delegate Valentine, sorry.
Thank you, Mr. Chair. Can you clarify, is this for stolen firearms or lost firearms? Because I've heard you testify to both.
Could be lost or stolen firearm. When we currently have a lost firearm or stolen firearm, you report that firearm is missing, right? So this is going to give you the opportunity to locate that firearm using this tracking software.
So you're talking about a firearm that's just lost, that would be an easy way to track that firearm back to its rightful owner?
Yeah.
Okay, so for example, if I reported my firearm lost, I would contact law enforcement, report that. They could conduct an e-trace through ATF, like you said. They would then track that back to the dealer it was distributed to, and then back to the owner it was purchased from, and then that would basically just return that firearm to its owner, so I wouldn't need this chip. Would that be correct?
Well, the problem is you can't find that gun if you don't have the chip, right? All we have is a serial number right now with E-Trace, with most guns.
I thought you had the okay.
No, ask the question. I want to make sure I'm clear. The firearm doesn't automatically have this in it already. This is what we're proposing, is that the firearms have that in it.
Okay.
Right?
All right. Thank you.
Okay.
Further questions? Seeing none, we thank you very much. Hear from, on this one, no? Thank you. We'll hear from those people in opposition. Galen Muhammad, John Jocelyn, Mark Pennack, Brett Omspaw. See Mr. Jocelyn.
Did that without a tracking device.
Okay. Mr. Muhammad is virtual. We'll get to him right after Mr. Jocelyn. Go
Mr.
ahead.
Chairman, Mr. Panic was called away for a meeting. He couldn't be here. John Jocelyn, speaking for 2A Maryland, in opposition to House Bill 704. 5901C1 requires that the tracking device be embedded in the receiver. This means it must happen at the manufacturing level. However, the manufacturer has no way of knowing where that firearm is going to be shipped. Any aftermarket attempt to install it may render the firearm dangerous and will obviously void the warranty. 5901B defines a bulk sale as more than 10 in a transfer, but 5902C says more than 10 per month. The definitions clash with one another. You'll see in my attachment 3, the military has indicated they do not like these on things that are going anywhere outside a controlled area. One of the concerns is that you can reprogram the chip. The question of privacy, you're installing a tracking device in someone's personal property without their knowledge. This is a clear violation of the Fourth Amendment. I'm sure when you look at Mark Panick's written testimony, you will see more on that. This program is one of those things that H.L. Mencken said, for every complex problem, there's a solution that's simple, easy to understand, and wrong. This program doesn't do anything that we don't do currently now just as well. Multiple sales are required to be reported to the ATF, and we are a one-gun-a-month state. What this bill will do is reduce dealers to being able to sell less than 10 firearms per month. The bottom line is it's a solution in search of a problem, and quite frankly, I don't see that the cost of $3.4 million a year will give us a good return on our investment, and that's 3.4 in the first 2 years and 1.6 following years. We ask for an unfavorable report.
Mr. Mohammed for 2 minutes, please. You need to unmute yourself.
Sorry.
Okay, off you go.
Great. Good afternoon, Chair, Vice Chair, and other delegates. My name is Galen Mohammed. I'm calling because I've heard, after hearing the initial testimony, I'm calling concerned about who absorbs the cost of this $3.4 million. More than likely, that'll be passed along to the end user for the cost of adding those chips to those firearms. And I guess my secondary concern is if this is being done for public safety, my concern is, or my suggestion would be to remove the exemption for military personnel receiving their wear and carry licenses. I ask that this bill receive an unfavorable standing. Thank you.
Questions for the panel? Delegate Conaway.
Thank you, Mr. Chairman. Thank you, panel, for coming in to testify. Now, my question is it possible that law enforcement could ping one of these guns like they ping a cell phone if the registered owner is being sought after?
It is possible to ping one of these chips. However, what you're looking at is a distance issue. There are two types of RFID chips, passive and active. The passive chip receives the RF energy, which is radio frequency energy. It's broadcast me to you. You have the chip senses it, and it gets its power from the transmission and sends back. Very limited range. Now, if you have an active RFID that has a battery, it has a longer range. You may ping out, and the chip may or may not be able to reach back to you. But once the battery goes dead, it becomes ineffective.
So in the long-range chip, you're talking about installing not only the chip, but a battery like in your cell phone?
You would have to have something active to power it, otherwise you're not going to get that low jack effect.
And then so you potentially might have to recharge it every once in a while like our computers?
I don't know many gun owners that would recharge that battery.
No, I'm just saying, thank you very much.
Further questions? Seeing none, thank you. Delegate Young.
Won't be long, Mr. Chair. Thank you. You mentioned the Fourth Amendment with regard to the RFID chip. My question, and you said that we would be embedding it and it could be a violation. But don't we have those same chips on credit cards?
Credit card isn't a constitutionally protected item. And yes, you do have them on your credit cards. And yes, a lot of people are very concerned that people will actually be able to steal their electronic signature and use that data in a reprogrammed chip, because these chips can be reprogrammed, and that was one of the issues the military had.
Okay, thank you.
Further questions? Seeing none, thank you very much. That concludes the testimony on House Bill 704. Going now is Delegate Smith. Here, there's Delegate Smith. House Bill 1192. Do you have anyone with you? Just you.
Oh, thank you. I was supposed to say again.
Go ahead.
Okay, thank you. Hello, Mr. Chair, Mr. Vice Chair, all the distinguished members of Judiciary. For the record, I'm Delegate Stephanie Smith, and I'm here to present House Bill 1192. Now, this is a bill that's really focused on kind of reconciling some of the great work that was accomplished by this body recently, particularly with the landmark juvenile justice reform legislation that was adopted. We feel like this bill is a great marker for maybe expanding upon the conversation for some of the gray areas that exist, particularly for minors, young people that are unfortunately engaged in animal cruelty. We've often heard about the fact that young children hurting animals can also be a signal that they themselves are experiencing some type of hurt, neglect, or harm. Specifically, young people who hurt animals are twice as likely to be victimized. And also there's compelling research around sexual abuse of children and how that can manifest in animal cruelty efforts. So what we want to do is ensure that young people that are exhibiting these types of behaviors, they not only get the help and resources that they need, but that there are proper processes in place for animal control officers and other related actors to remove those animals on a temporary basis as it is evaluated who actually perpetrated the harm, while also connecting those young people alleged to have committed these terribly cruel acts with the resources they need. A few examples of what we're talking about just locally in Baltimore, for example, a 6-year-old girl placed a cat in a microwave oven, and an 8-year-old girl killed a homeless cat. And so we know that that type of cruelty, it's coming from somewhere else, and I think it's incumbent upon us to try to figure out how we can reconcile the services provided by our animal control officers with their ability to connect with the appropriate resources and other officials that can ensure that that young person is getting the help that they need. Also, I wanted to lift up that we recognize that within the current draft of the bill, there's going to be a need for some revisions to make it workable, particularly Section C around the processes related to what is outlined as animal seizure. We want to probably term it, just to better explain what we're talking about, as more of a temporary custody, not really, I guess we could say it's analogous to sometimes children being removed from unsafe circumstances for temporary custody of CPS, just giving you something to compare it to. So we do, anticipate that this bill will need some work, but we want to be in thought partnership with this committee around what that can look like to ensure that we're honoring not only the safety of the animals, but getting the young people that are often in harm's way the things that they need to. So thank you for listening and for helping us to improve House Bill 1192, and thank you for your time today.
Thank you, Mr. Chairman, members of the committee. My name is Jennifer Bevan Dangle. I'm the state director here in Maryland for the Humane Society of the United States. We're very excited to start this conversation with this committee, and we thank the sponsor for taking this bill. We're really charting new ground here. Historically, as you know, so much of our structure is about criminalizing, and then that's the only tool you have to engage when something has gone wrong. We look forward to being able to work with this committee to forge a path that's about deploying the correct types of assistance to make sure that the children who are involved in these acts are getting the mental health supports, the social services supports they need, but also making sure that the animals can be removed when necessary for their own safety without any type of criminal charges being brought. And that's really the gray area we're in here. And you'll hear more from my shelter partners who are here and with us virtually about these cases. When animal control feels their hands are really tied, they are concerned about the health and safety of the animals in the home, but without any type of criminal charging, it's unclear what authority they have to act. We agree with the sponsor, the language in Section C, which is that seizure language. You know, we asked for this bill a little bit late, and we came back with some confusing language here. We're well aware that that needs to be overhauled. We appreciated the chance to speak with some of the opposition earlier. We think there is a path forward here that focuses on temporary custody, and again, sort of looking beyond animal care laws or animal seizure laws, which don't give us any good models right now, but looking at where can we lift from maybe other sections of the code, perhaps such as the foster youth code, to make sure that these animals can be brought into a temporary custody situation while the issue at hand is being resolved. And then the bill might still need some type of civil seizure process because it's not statewide available to have a civil seizure, where if an animal is deemed, or if it is found by, the services that come in that this is truly an unsafe environment, that the animals could then go through a civil seizure process and be removed permanently. But we understand that's going to take quite a bit of work, and we look forward to working with this committee and the opposition to navigate that.
Good afternoon. My name is Katie Flory. I'm the Community Care and Advocacy Director with the Maryland SPCA. I've been working in this field for 18 years, working with animals and with children. I have run several humane education programs, and I want you all to really think about where we're heading as a community. We don't want to see children incarcerated, but we do not want to see animals or children hurt either. Please, let's not wait until something extremely serious happens in our state where we are reacting instead of being proactive. We're actually extremely excited to work with this committee as well as the opposition to find a path forward, to be the state that's looking ahead of the game instead of waiting until something very serious happens that we will all see on the news and we will all feel absolutely horrible that it happened. We have an opportunity as a state of Maryland to make a difference now. So I ask that you please provide a favorable report, work with us, help us figure out the best path forward to keep children and animals in the state of Maryland safe. Thank you very much for your time.
There are 3 people signed up to testify virtually. Lisa Radoff, who I don't see, Patty Crankshaw Quimby, who I do. So we'll hear from her for 2 minutes, and Nancy Blaney for 2 minutes. We'll start with Ms. Crankshaw Quimby.
Good evening, and thank you for your time. My name is Patty Crankshaw Quimby, and I'm the president of Professional Animal Workers of Maryland, as well as the executive director for Talbot Humane and Talbot County Animal Control. PAWS is a state association comprised of animal control agencies and humane societies, and we stand in support of House Bill 1192. The link between animal cruelty and violence against humans, including intimate partners, children, and elders, has been documented. When we see these behaviors arise in childhood, they are often a marker for issues of serious concern, from the child witnessing or experiencing abuse themselves to mental health issues. In October of 2022, a 12-year-old Anne Arundel County boy beat his great-grandmother's small dog to death using dumbbells. He hid the remains of the dog. He then placed his bloody clothes in the dirty laundry hamper. He has a history of concerns. There's currently a second dog living in the home with the great-grandmother and this young man. In Baltimore County alone, there were 5 cases in the past 12 months of juveniles 11 to 17, and in Carroll County, 2 in the past 12 months. These numbers may not seem like a lot, but the question is not if these acts are occurring daily, but that we must have an avenue for intervention when they do. Currently in Maryland, when a minor is suspected of such acts, there is little to no recourse for intervention. The child, the animals, and other humans alike are put at risk when we can't address these acts. We support this bill, and we support working with the sponsors in opposition to on needed changes to ensure the safety and protection of people, pets, and these children. We respectfully ask for a favorable report.
Ms. Blaney, then Ms. Radoff. Ms. Blaney, you're going to have, there you go, for 2 minutes.
Thank you, Mr. Chairman. Thank you, Mr. Chairman and members of the Judiciary Committee. I'm Nancy Blaney, Director of Government Affairs for the Animal Welfare Institute. And on behalf of our Maryland members, I want to thank you and the sponsor for this opportunity to testify in support of HB 1192. One of the most dangerous things that can happen to a child is to kill or torture an animal and get away with it. Sit with that for a minute and I will come back. Columbine, Parkland, Buffalo, Uvalde. Besides the obvious, what do these mass murders have in common? Their perpetrators had histories of animal abuse. Building on what the previous witness just testified to, time and again we learn that individuals, including juveniles who have committed violent acts against others, often have a history of abusing animals. Animal abuse occurs in communities across the country. It is a serious crime on its own, but there is the significant link between animal cruelty and violence against humans. In one study, 70% of the convicted animal abusers whose records were reviewed had committed at least one other crime, and 40% of that group had committed a violent crime.
100% of those involved in sexual homicide had a history of animal abuse. The same study found that animal abusers are 5 times more likely to commit violent crimes than non-abusers. Not all children who harm animals grow up to be mass murderers or spouse abusers, but it is a risk factor that needs to be looked at, and also to make sufficient resources available for intervention and rehabilitation. So back to Margaret Mead. Margaret Mead didn't have all of this research at her disposal when she said that, but sadly, time has proven how right she is. Enacting HB 1192 will help us to avoid forging that particular link in the chain of violence. Thank you.
Ms. Radoff, please, for 2 minutes.
Good afternoon, Chair Clippinger, Vice Chair Moon, members of the Judiciary Committee. Thank you for the opportunity to testify this evening in support of HB 1192. The hour is late, and my colleagues and the sponsor have made very important points that you know about the link with this law. I just would like to let this committee know how grateful we have been over the years to work with you. This committee has a history of taking strong action on difficult issues that involve cruelty to animals, such as animal sexual abuse and dog fighting. We would like to take this opportunity to work on this issue, which affects people and animals, and go forward to help our state realize a safe environment for people and animals and everyone in the households. We understand that there are some provisions around seizure that need to be addressed, and look forward to working with this committee. Thank you so much to Delegate Smith and to all of you for taking this issue very seriously. Thank you.
Questions for the panel. Delegate Pasteur, then Delegate Simpson.
Good evening. Good evening. And thank you for this. Thank you, Mr. Chair. Thank you for this, because it certainly, as you described, is a sign. Yeah. So we want the animal to be safe, but the child certainly needs to be supported. So in the example that was used of the child who killed grandmother, great-grandmother's dog, and the child is still in the home, and there's another dog, under this bill, what would have happened to the child? How would that have played out?
So I don't want to speak for the animal control officers in Anne Arundel County who know the full details of their response, but the goal with this bill is that instead of just contacting CPS and saying, we want to flag this, it's an issue, you should look into it, the animal control agency would have the ability to truly call in social services and require that someone come out and provide some of those supports to the child in the home to make sure that that child is not being victimized, but also to ensure that the other people living in that home, such as the grandmother, are safe as well. And right now, there just is not a clear path for ACOs to sort of compel action by a social service agency, because historically they've been so separate.
So are you saying that all of the parties are involved in this so that we would know if this bill is passed, this will happen, this will happen, animal control will know who to call, and it will go right into action, so there's no real gap for the child? Because I see what will happen to the animal, or for the animal, but I want to make sure that the child really is, there's a line, a path for that child.
Yeah. I mean, that is the goal of the bill, and again, we look forward to working with this committee to make sure that if there's any agencies that should be specifically called out in the bill as a response unit, that they are included. So we're very happy to make sure that that first part of the bill is also as thorough and comprehensive as possible.
And Delegate, I just want to mention that this bill is very much like a marker, because it's reconciling professionals that don't always really interact with each other. And I think many of us are familiar with people that are doing good work in different government capacities, and they might identify a challenge, but it's not their responsibility, or they're not empowered legally to make something happen. And so we want to be in thought partnership with the committee around how do we empower that animal control officer to get that response from those folks that provide the human services element to triage immediately with that young person, because the things you just heard, those are frightening behaviors for very young people to be exhibiting.
And that's a lot of empowerment, isn't it? Because it really involves a lot of immediate attention and a lot of immediate attention from people will say, my caseload is full. Yeah. Thank you.
You're right.
Delegate, I love this bill. Absolutely love it, and I really appreciate it. Because I did have a case many years ago in which a child there's a strong, strong link between child sexual abuse and animal cruelty. And, you know, no one had ever been successful in making that link between how do we coordinate those services. You know, one in which this young man was sexually abusing actually his sister and put her rabbit in the microwave. So, to say the least, I really like it. I just don't see here where the coordination with the Department of Human Services, and I know where the problem is going to be, which is what do you report? Because typically it's like, is it neglect? Is it abuse? Is it sex abuse? You know, what is it that we're investigating? Although I do think once you say animal cruelty, I think they do know what they're going out to look. As far as checking on the grandmother, we know when it comes to adult services, that's a little funky. But there is a strong correlation. I would probably, instead of may and leaving it on the officers, I would probably say that there would be like a required, you know, like the mandatory reporting, that it would be a required reporting. And I would also say I would like to see a little bit more sit down with, I mean, I'm sure it won't take long. You could just, you know, for them to give you some idea of what the language that would tighten it up a little better to make that report.
You're welcome, though.
I mean, so, isn't that so?
Yes.
Further questions for the panel? Delegate Conaway.
Thank you, Mr. Chair. Thank you, Madam Chair, Delegate. And thank you, witnesses, for coming in. Page 1, line 21. What is an authorized agent of the Humane Society?
So it could be an animal control officer. It could also be someone like me. Again, I'm a director with an animal shelter, but I work with children every day. So if I...
So that's good. So
Yep.
my second question is, you would conduct an investigation.
Or it would be my job to report it to the appropriate authorities, because my role is not an ACO, or I do not have those powers.
Well, it says here on line 21 to 22, shall conduct an investigation.
And that, and again, I don't want to speak for the language of others, but I would say in my personal situation, I would then report that to my local animal control, who would then do the investigation, which means I
What I'm
am.
trying to ask about is my personal reading comprehension that says on line 21, shall, and then line 22, conduct an investigation. Because what I'm trying to get to is, by what authority do you have to question a minor?
I wouldn't have that authority, but if I am the person that is working in a classroom where I am told by a child that animal abuse has happened, or I suspect that child would be, I would be a required reporter. So the language, I believe, and again, I think we are working through how we need to change the language, would be it is my responsibility to report it. I am then starting that investigation, getting it to the proper authorities who have the authority
It says
to do it.
conduct, not start. So I was just,
Yeah,
since
that-
we're trying to get the language.
This is what thought
correct.
partnership looks like, Delegate.
This is what-
This is thought partnership in action. You're here because, like she mentioned, I was, just rushing down the street, and she's like, "Could you put this bill in?" I said, "Yes." My heart is big. I love animals. I love children. Let's see what we can get started.
Well, this
And
is
so
won-
there's
this
work
is
to be done.
wonderful, but just because a certain child kills a dog or something, I
Right.
don't necessarily want them to be a victim of ongoing monitoring.
Understood.
Okay, thank you very much. Don't tell me okay.
Delegate, any further questions? Seeing none, thank you all very much. We're now going to hear from one person in opposition, Jeremy Zacher. Is he on virtually? Okay. Mr. Zacher, for 2 minutes, please.
Thank you, Delegate Klippinger. Good evening. My name is Jeremy Zacher, and I'm an assistant public defender in Baltimore City, where I've worked in the juvenile division for 9 years. The Maryland Office of the Public Defender asked this committee to issue an unfavorable report on House Bill 1192. House Bill 1192 is written in overly broad and vague terms. House Bill 1192 allows law enforcement and a social services agency to become involved in the life of a minor simply because there is reason to believe that the minor has committed an act of animal cruelty. Once this reason to believe standard is satisfied, a social services agency may conduct an evaluation of the threat the minor poses, but does not state how that evaluation is to be carried out or what standard the agency should use to determine the threat. This same social services agency may conduct ongoing monitoring of the minor without parental consent or court order. This ongoing monitoring of the minor has no end date and no standard by which it should be conducted. House Bill 1192 allows indefinite monitoring of a minor without even being found guilty of a crime or delinquent act. House Bill 1192 allows the law enforcement officer or authorized agent of the Humane Society to seize a family pet merely based on suspicion of animal cruelty alone. Thus, minors who are merely suspected of animal cruelty are treated as if they are guilty. No hearing or due process required. House Bill 1192's terms are undefined. It ensnares children of any age for evaluations and monitoring without parental consent, and the bill has no time limitations on how long monitoring would last. House Bill 1192 sweeps too broadly and provides no exits for families who fall within its grasp. We ask this committee to issue an unfavorable report. Thank you.
Questions? Seeing none, thank you very much. That concludes the testimony on House Bill 1192. We're now going to Delegate Weigel. House Bill 845, please. Oh, I'm sorry, no, this is Delegate Addison. I'm wrong. Delegate Addison, 974. Who would you like to bring up with you?
I have my panel with me. Monzi.
Okay. Say again? Okay. Shantae Jackson, Mark Mason. Margaret Smith on virtually. LaToya Tyler. Okay. All right, Delegate, go ahead. You can start.
Good evening, esteemed members of the Judiciary Committee. My name is Delegate Addison, and I stand before you today to wholeheartedly endorse HB 974, Public Safety Gun Violence Victim Relocation Program establishment. This bill would create and fund the Gun Violence Victim Relocation Program in Maryland. As you all are aware, well aware, gun violence is an issue of paramount concern in our state. Baltimore City came off one of the most violent years in the 2020s with 332 fatal shootings and 687 non-fatal shootings in 2022. Baltimore and throughout our state, we do not support gun violence victims as they process their trauma. Often we leave them forced to live in areas where they have experienced unspeakable trauma. Additionally, we know it is not uncommon for survivors of gun violence and their families to take matters into their own hands, thus creating a cycle of retaliatory violence that must be disputed. On the first day of session, Delegate Young and I received a text message that someone that had been shot in our district. I saw the location of the shooting and my heart dropped, as it was the same street one of our door knockers lived on. It turned out to be him that was shot just a few doors down from his house. Thankfully, it was not life-threatening. This young man was let out of, I'm sorry, I'm just nervous, hospital that day. Yes, I'm trying to beat the time. Hospital that day and returned home to the same street he was shot on. The fear and anxiety this young man faces is indescribable. He had to return to the area where his life was almost taken with little to no support. I'm just going to end there, right there. I have a whole lot more, but I wanted to just say that this right here is really personal for me, for gun victim violence. We know that in Baltimore City, where I live, especially in the 45th district, we have a lot of homicides. In fact, we had 13 homicides and 23 shootings and 162 aggravated assaults. And most of those people do not have anywhere to go to be relocated. They just have to go back to where they are. So I'm asking that you will give us a favorable report. I know that you have this in front of you.
I will start. Good evening, Chair, Vice Chair, members of the committee. Thank you for the opportunity to testify today. I am Shantae Jackson. I'm the Executive Director of the Mayor's Office of Neighborhood Safety and Engagement in Baltimore City, here to support with amendments House Bill 974. I can't overstate the urgency associated with the need for relocation of victims in the immediate aftermath of gun violence, because quite simply, lives are at stake. The reality is that survivors of gun violence might either be dead or re-victimized by the time an arrest is made. To bring this home for folks, I want to share a bit of information about a student that Monsi is currently supporting. We've seen this student be shot twice, non-fatally, in 3 days. And the second time he was shot, his mother was also shot, non-fatally. Monsi is working tirelessly to relocate students along with other gun violence victims for their safety. In addition to saving lives, the relocation of gun violence victims, not only those direct victims, but their family members, intended targets, allow individuals to cooperate with law enforcement when they're ready without fear of retaliation. Baltimore's had a gun violence issue for a really long time. It's one of the reasons why that's prioritized as Mayor Scott's top issue. Another example of the work that Monsi is doing right now is a partnership with Baltimore City Public Schools in the aftermath of the homicide of Isaiah Carter just 2 days ago outside of Patterson High School. In the absence of dedicated funding, Monsi is working with other city agencies, external service providers, and local business owners to help us quickly relocate people. And just last year alone, we were asked to relocate almost 30 families with no funding. I am asking for you all to provide a favorable report with amendments to House Bill 974. Thank you.
Good evening, Mr. Chair and members of the committee. My name is Mark Mason. I am the Associate Director of Victim Services for the Mayor's Office of Neighborhood Safety and Engagement in Baltimore City, here to support House Bill 974. Monsi has several unique roles in Baltimore, with one of those roles being serving victims of crime. Examples of that work may look like collaborating with another city agency to assist a mother with relocation funds after a 15-year-old daughter was shot, or a 28-year-old man shot in the exact same neighborhood where he currently lives and is now afraid to even step out of his doors in fear of being shot again, or a mother that regrettably found out that her 16-year-old son was shot by an individual who lived 2 doors down from her rental office and has to endure the difficulty and setbacks of being relocated due to not meeting the requirements of acceptance to a new property management company, which would not only give the family continued safety, but peace of mind as well. Monsi has worked directly with other city agencies to provide these similar services to more than 200 families this past year, with 75% of them receiving intensive case management and service delivery. House Bill 974 would give our victims of crime, or allow our victims of crime, deserve our most dedicated efforts to their safety and well-being. Relocation always plays a major role in that for victims, and this bill would just set the standard for what adequate and effective victim services should not just appear to be, but show in actuality. Thank you.
Good evening, members of the committee. My name is Heather Warnken, and I am the Executive Director of the Center for Criminal Justice Reform at the University of Baltimore School of Law, here in strong favor of this bill, also with amendments. In my prior role at the U.S. Department of Justice, I had the great honor through the National Public Safety Partnership Program, PSP, in collaboration with the City of Baltimore and a number of partners, to lead an assessment on the response to victims of violence. It was focused specifically on Black and brown victims of gun violence. And the resulting report covers a number of different topics. It's quite expansive, but one of the key topics within that report is relocation and how critically important it is and the current gaps and limitations in meeting those needs, especially for the people who need it the most. And just to underscore, this isn't just about the dignity and healing and sanctity of life, of those lives that Director Jackson talked about that are at stake. This is also about prevention, which means it's also about public safety. So the report detailed across its 91 pages a number of the ways in which we are currently missing those opportunities for prevention by not being able to provide these needed relocation services. And I'm happy to share the report with anyone who doesn't have it. The section starts on page 26. On a more broad level, the report details the explicit but also implicit barriers within the system that too frequently lead, especially for victims of gun violence, to be seen as perpetrators of harm and criminalized rather than seen as victims, leading to eligibility exclusions. It also, I'll just say very quickly, among the other things it covers, the gaps in other resources it takes to make this happen. This isn't just about the housing. You know, there's food, there's transport, there's a wraparound need to get people successfully relocated. And then lastly, the mental health and wellness needs of the people who do this work, that if they are spread so thin, both their liability and what this takes of them can be especially draining and taxing. And I'm happy to answer any questions. Thank you.
Any questions? Delegate Pasteur, then Erican, then Young, then Kaufman.
So I really thank you, Mr. Chair. I really want to thank you for this bill. And there will be those who really can't wrap their heads around it. So before I ask, and I do have a question, but I had a student who watched a gang murder, and she was and her family were relocated to my school. Even though I don't like the way it was done, and I found it disrespectful, but at least somebody knew she had to get out of that life. And I can say that in a year, I watched her and her sister change who they were, and I see them from time to time. It made a difference in their lives. So my question to you is not a question. Explain, talk about that paradigm, how just moving folks out of an environment changes lives, so that it is not something that's ethereal, that, okay, let's just spend some more money and move them somewhere, because it's not about anybody giving the money to them. It's about just changing where they are. Can you just explain that a little bit more that's off the paper so people understand?
So you want me to explain it for you?
Yep,
okay.
Thank you.
So right here, I don't know if you received this. And this is Angela Dawson, and that's why I say it's really personal for me. In 2002, Angela, if she had been moved from her home where she had reported, she repeatedly reported to the police about drug dealers out front of her house. She lived blocks away from me in the 45th district. Drug dealers came back, killed her and her 5 children. And so this right here, moving these folks, if she had been moved, she probably would, her and her children probably would have been living today. So this is why I say that this is very important to me. It's very personal to me. And so this is why this bill is also important to me. You're welcome. Oh, you're welcome.
Thank you so much for being here. Hopefully your first experience with the Judiciary Committee is less scary than what our reputation often is. And thank you for bringing this in. These can be hard for us to look at, but we're on this committee because we're supposed to look at the faces of the people who are damaged by, bad actors, and also sometimes by our failed policies. So I've got a couple questions. I don't know if you've had a chance to look yet. At the Office of Budget Management, they had sent something in mentioning a couple of different programs. They mentioned there's $300,000 in the artist formerly known as GoCap. We don't know how to say that, the new version of it down here. We just keep GoCap. And then there's also $297,000 in the Stop Gun Violence Fund. I'm not sure if you guys were aware that some money is existing. Obviously, it's woefully inadequate. And I know that the previous state's attorney also came down many times to really beg us to give more money to protecting some of these victims. So I'm sorry that we failed to do that so far. So I don't know if you want to comment on any of that. And then I have a couple more questions, mostly along the lines of how long do you anticipate expenses needing to be covered for people? And then do you have any mechanism to shield their identity so they're not further victimized going forward?
Shante, answer that. I'll answer some of your questions. Thank you, Delegate. With regard to the funds specifically allocated for the state's attorney for relocation, want to advise the committee that the state's attorney cannot effect a relocation without a cooperating witness. That typically happens after an arrest has been made. And as I mentioned in my comments, someone could be dead before an arrest is made. In the immediate aftermath of violence happening, that's when our team is literally on the ground. I can tell you all, just following the homicide 2 days ago, that Mr. Mason on my team was called by me while he was at a conference for us to effectuate a relocation immediately for one of the young people that witnessed the homicide. And so want to make sure that we're separating out the state's attorney's dollars with regard to what that can be used for as it relates to relocation. And in fact, the Baltimore City Administration is working on a budgetary line or fiscal note change that would potentially affect making those dollars available to Baltimore City in general instead of just to the state's attorney.
Okay, interesting.
With regard to your question about the length of time through which we'll provide services, it depends on the agency, quite frankly. I believe that the Baltimore Police Department, whose victim services unit we work closely with, will provide services for up to 2 years. The Baltimore City Health Department and Monty work pretty closely together, and those services are provided for as long as folks need them. Now, that doesn't necessarily mean that we're paying folks rent or mortgage expenses indefinitely. We are making sure that as we relocate individuals, that there becomes a point in time where there's sustainability of and continuity of their ability to be able to take care of themselves. But with regard to referrals to mental health providers that you heard Heather speak about and or other supports, we're making sure that case management happens for as long as folks need it.
Okay, and then in terms of the shielding of their identity, do you have a system in place right now that does that?
Yes. I'm sorry. Yes, we actually have partnership with Maryland Safe at Home.
Mm-hmm.
It's actually a program that we've been trained to be able to enroll individuals in that will write their addresses clean.
Mm-hmm.
And they would actually receive their mail through a P.O. box. So even courts wouldn't have access to their new address or any other entity.
Wow. Okay. And when you move them, are they staying inside the state, or can you also relocate outside the state?
We have
Okay, because
yes,
we're a tiny
we have
state.
relocated house. Yes.
Yeah. Okay. Wow. This is.
I mean, as recently as just a few weeks ago, we had a conversation with a family that indicated that they needed to move out of the state, that they did not feel that it mattered where in the city they moved, that there were potentially going to be some safety issues.
Yeah. I mean, I see people I know all the time in places I would never expect to see them. It's really, frankly, scary. So maybe you can take a look, and if you don't have it, I'll send it over to you, the Office of the Budget. They make a little complaint at the end about how expensive Kerwin is. But I think kids can't learn to read if they can't be alive. So thank you very much for coming today.
kind of bring this full circle for you all, yesterday you met Archie, who we talked about with the reward money. Archie's nephew is the person that we're talking about here that was shot, and that is the impetus of this legislation. I want to also thank Mark, because Mark is the person who I called to help with Archie's nephew after he was shot, and he's been working with him ever since. And I'm grateful for the work that Muncie has been doing and will continue to do, hopefully with the support of this bill. This bill is drafted to create a state program. Shantae, can you just clarify, you all are asking an amendment for the money to be able to come directly to you, is that correct?
I think that what we're asking for, sir, is the opportunity in partnership to figure out what criteria is appropriate associated with these relocation funds and to determine how the funds would be administered. We would obviously want to do that with you as with the sponsors and also with our community-based partners.
Thank you so much. And can you all just give a high level on, you've been doing this work for not very long. So for how long have you been doing the work? How many people have you been able to move? What's the general top line or bottom line cost that you've already incurred so far?
Thank you for the question. I would offer that while the city of Baltimore provided victim services for residents who were dealing with intimate partner violence or sexual assault or human trafficking or other types of victimization, it wasn't until the Scott administration that a decision was made that we were going to be deliberate about not treating gun violence victims as perpetrators, but as the victims that they are. And so this work is relatively young. We just started, no pun intended, sir. We just started last year in 2022 with Muncie standing up its own victim services lane. And I'll leave it to Mark to talk to you about the numbers of folks that we have helped so far. I think he mentioned that in his earlier testimony.
Yeah, approximately 200 just this past year, with about maybe 90 of them actually getting relocation funds. And as far as spending over the past few years, close to $400,000 in relocation funds. I mean, it varies because you have stipulations that restrict some families from being able to move. We may have to put double security deposit down. We may have to ensure that we are paying 6 months to a year for some of these families to be able to be relocated because, the landlords are just, really particular about, allowing them to move. So the funds actually increase based on the need.
Thank you. And Mr. Chair, last question for Heather. Mr. Walken, you mentioned that some of the language is kind of broad, and you would like to see it kind of cleaned up. Could you just opine on kind of, we want to make this very accessible. So how would you recommend that we adjust some of the language?
Sure, I really appreciate that question. And I would say that again, drawing on the PSP report, I think a number of the findings and recommendations there are instructive to this. As you've been hearing, I think when we led that assessment out of the U.S. Department of Justice about 2 years ago, I think the Muncie team has really completely changed the context here, and their ability to deliver services out of Muncie has made this far more accessible and effective, but I still feel like it's bailing water out of the ocean with a thimble compared to the actual need. At the time we did the assessment, we sort of honed in, one of the key findings was it wasn't just a gap, but really a canyon, given the over-reliance of these resources in the state's attorney's office. So again, I think there's just an incredible opportunity here to fill that gap. Where I'm honed in on the language of the bill as it currently stands is around eligibility. So the part that stands out to me the most based on our PSP assessment findings is that you can deny someone if they are suspected to have perpetrated the violence. This is an incredibly complex and hard determination to make in real time, especially if someone has ever touched the system before, if they have relationship with the people that harm them. And as I think has already come out in the testimony, to date, we have spent so much outsized energy on the front end trying to figure out categories of worthiness and eligibility, and we miss the boat that I think Director Jackson and others have talked about to actually get them relocated in time to prevent a retaliatory shooting. So I'd really want to change that eligibility language and clean it up so that this fund could actually be accessible to the people who need it the most and who historically we have well documented now have not gotten it. And I'll point out two other examples in the language. One, what does close proximity mean? And then another, how do you demonstrate the need? These are things that if it's too broad, history and prior experience with access to some of these programs showed us that people aren't going to be able to overcome those barriers, and they're definitely not going to overcome them in time.
Thank you so much, and especially thank you to the team at Muncie for the good work you're doing to make our city safer. Thank you.
Absolutely.
Very briefly, I only have one question. First of all, I want to thank you, Delegate Addison, for bringing this important bill, and dear panel for doing really what's God's work. My question is, do you have a response to the $10 million fiscal note? And the other is a piece of advice. As you know, your district mate Stephanie Smith is a senior appropriator, so you might want to work with her on ways to advance this critical work while lowering the fiscal note a bit. Thank you.
Sure, I'll work with her.
Oh.
He's without. Oh. And I say, sure, I'll work with
You're
her.
going to work on the fiscal note?
Yes.
Great. Delegate Tomlinson, then Embry, then Grammer.
I like the idea of the bill. I don't think I've talked with you about this in the past, but I know I've talked with Delegate Young down here about just any ideas to try to help the city with violence and crime. I'm on board. I do have a question about the bill. I'm looking at page 4. It looks like page 4, and it references that it won't accept any individual into the program if the individual is suspected to have perpetrated the violence. So when I hear about this program, I keep thinking of witness protection. I'm thinking of movies a lot of times where they're putting the bad guy who tells all the secrets and they send him out to Idaho or somewhere out west. I don't even know. But would folks who have committed crimes, especially crimes with guns, or actually murdered anybody, would they be eligible to get into this program, or no?
So just thank you for your question, Delegate. Just a couple of points here, and I think one, I'll just tell you a story. We've got 15 young people standing on a corner. One of them shoots another. How do you know who's the perpetrator if they all scatter? And so just by, this language not necessarily being clear around a potential perpetrator of violence, they're all people of interest. That doesn't necessarily mean that they're all perpetrators, right? And so would I want to provide relocation services to any and every one of those who had fear of retaliation or safety concerns, including the person who actually pulled the trigger? Yes. Because I wouldn't want there to be retaliatory violence against that person. I would want the justice system, our partners at the Baltimore Police Department, our partners who are responsible for doing the investigative work to uncover who the actual perpetrator was of this violence, to do their job. And at that point, the criminal justice system should do what it's supposed to be doing. Also, with regards to your question associated with whether or not someone who's ever had a history of shooting someone, if they would be eligible for these sorts of services, I'm going to make the assumption that the question is about folks who are returning citizens or folks who have done their time. Maybe I should ask that question. Is that what you're asking, or are you asking if someone is about to go to jail?
Either way, really.
I think the larger question for me and what I would offer to the committee is, do we limit services at the risk of losing more lives? And I'd invite my fellow panelists to share any additional thoughts here.
I mean, I would just echo that and really reiterate it. And it's really the main theme in the PSP report that we are missing opportunities for prevention by focusing that way. And I will also say, we don't have, given the complexity of gun violence and so many of these situations, we don't really have good mechanisms to make some sort of clear or clean determination of that at all. We brought another bill that's, I think, has some very related themes to this committee last night about reforming victim compensation. And we have so many well-documented examples where someone gets excluded because they were deemed to, on the front end, have contributed to or been involved in their own victimization, and only later that's determined to have been inaccurate based on how that information was gathered. So I think by creating these categories of worthiness and eligibility that are meant to identify some sort of quote-unquote perfect victim, we not only set up a whole lot of work that undermines the effectiveness of the program, but we miss the opportunities to prevent the retaliatory shootings.
And also, I think the importance of interagency collaboration, working with BPD specifically to kind of do our due diligence in investigating and finding out, the full scope of actually what happened, which will allow all parties to kind of play a role in, how we move next. I think that's the most conscious way to be able to, determine, who to house. Just openly communicating with the state's attorney's office, openly communicating with BPD, I guess starts that.
I want to be really clear that a needs assessment is also completed. So it's not you just come to us and you say, hey, can you get me a new house? It is very much a multi-page needs assessment that gets completed on an individualized and a case-by-case basis to determine whether or not a relocation is appropriate or what other wraparound services would be appropriate.
Thank you so much, Delegate Addison, and also the work that you guys do at Monsi. I know how important it is and how hard. I have one question. It's a follow-up question from Delegate Young. I just want to make sure I understand. And then I have a second question. Currently, GOCAP in this field really just provides money to localities, and the localities do the actual relocation work. The bill as written envisions GOCAP doing the relocation, as I read it. You talked about amendments. I just wonder, is your vision, money comes to the city does the relocation, Monsi, or do you anticipate GOCAP having a role in the actual relocation?
Thanks for the question, Delegate. So when I mentioned specifically working with the sponsor around the administration of the funds, that's what I was referencing. Ideally, I believe that the administration should happen at the jurisdiction level.
I do. Thank you. I do too. The second question is, reading this bill reminded me of reporting in the Baltimore Sun last year about $8 million in state funds that went to this, or was supposed to be spent by the city state's attorney's office for relocation. That's a lot of money. I just wondered if there have been conversations about whether some of that could be reallocated for this program. Thank you.
Thank you for that question as well. We have spoken with what we will call the GOCAP office, because I can't pronounce the acronym either, repeatedly about this. And what we have learned is that there are about $2.3 million in funding. And as I referenced to the committee before, I believe the previous administration put a fiscal note in that funding that specifically indicates that it gets paid to the state's attorney's office. And so a simple update to that fiscal note, because no legislation was written that just says City of Baltimore, would allow that funding to be split across, you know, the state's attorney's office and the city, ideally Muncie. They're quite frankly, given that the state's attorney's office can't provide relocation services until an arrest has been effectuated and you've got a witness that's going to testify, it's impossible for them to spend $2.3 million a year to do that, just given what the arrest numbers look like in Baltimore City compared to the need right now for relocation, whether we're talking about for gun violence or for intimate partner violence or for rape. If someone breaks into your house, or for whatever level of victim supports are needed for folks who are interested in relocation.
I'm sorry to ask a follow-up, may I ask, Chair? And I remember this issue. There's really nothing that restricts the city from having a single entity responsible for relocation, regardless of the status of the investigation or charging. Has that been explored? I've always thought there would be some efficiency to that.
I would say that one of the key findings coming out of the PSP report that you hear Heather and I repeatedly referring to is making sure that there is an integration of the work. And so, yes, that work has begun under Mayor Scott's administration. We are in what I would classify as step one of what will be 3 steps associated with bringing that work together. The state's attorney and his team have been excellent partners coming into this work, and we're slated to have a conversation in the coming week with regard to the integration of our victim services work.
Thank you, Mr. Chair, and I'll segue from Delegate Embry's question. So we have the Victim and Witness Protection Fund, right? It was my understanding that the funds that went to that fund were for this purpose. Can you help me understand, other than a shortfall of funding, what are the problems there? Why can't we go through that fund for this purpose?
If I'm understanding that correctly, that also has a reliance on the state's attorney's office. And I can't emphasize enough how limiting that is to attach it to once an arrest has been made and a prosecution's moving forward, especially, and this was one of the main findings related to this with the PSP report, especially with non-fatal gun violence, what a small percentage of cases are actually getting to that stage. So any funding mechanism that's relying on that will be incredibly limiting.
And an agreement that you're going to testify.
Right.
So all of those things have to be factored in order for the state's attorney's office currently to effectuate a move. When, in fact, an arrest may never happen, or it may happen weeks, months, years down the road, and you're still very much in fear for your safety and or your life.
So part of the bill is the money goes to the jurisdiction. Part of the bill is we don't have to wait for prosecution. And part of the bill is that we have a suspected victim, witness, person in danger, and it broadens the application or the applicability to kind of get those people out of the way, so to speak. Am I reading that? Did I do that right?
Yes, just one minor change, because words mean a lot to me, that we get those people to safety.
Thank you.
Seeing no further questions for this panel, thank you very much. That concludes the testimony on House Bill 974. Going to House Bill.
I signed up. Considering I'm the one who runs the state program, I'd love it.
Come on up. Steve Kroll.
Mr. Chairman, members of the committee, good evening. I'm Stephen Kroll, the State's Attorney Coordinator and the Executive Director of the Maryland State Attorneys Association. What you don't know is I've been head of the Victim Relocation Program since January 2011. So I'm not a 2020, whatever, I'm 2011 dealing with victim relocation services. So if you have questions about what we can do and what we can't do, what I can tell you is I want to thank the delegate for sponsoring it and thank everybody who just testified. Without their help and support, we can't make victim witness lives better. So I thank them for their help. Does this bill need amendments? Absolutely it does. And I'm willing to work with them. I wish they'd have contacted me beforehand. I've been happy to tell them all about what we do and what we can't do. About how the Victims Board of Victim Services is redoing all the guidelines as I speak right now. How we have $1.4 million, not $2.3 million at the present time, which I've accounted for every single penny in my audit each and every year to GOCAP, or whatever they're called then. Plus the fact that you really shouldn't go through GOCAP because we don't even know who the executive director of GOCAP is right now. They're ill-equipped to present this particular bill and this particular money. But if it prevents victims from being repeat victims, I'm all for it. So what we do is we take $1.4 million we have left that should have been reallocated every year. But it wasn't because of many reasons. Too long to tell here, but I'm happy to tell you offline why the city doesn't get more money. More importantly, the $10 million should go statewide. It's not just a city problem, it is a state problem with victims and witnesses. Would I like to see the city get $10 million alone, everybody else get money? Absolutely, more the merrier. But it is a state problem that I deal with, that I have personal knowledge of every single day I go into my office. I get a phone call from some particular jurisdiction about a victim witness problem. This money is gratefully needed. We also need the workers to do it, people on the ground level. So I thank Monty. I think everybody's doing and trying to make a difference in people's lives. They are, and we need to continue to do so. But this bill needs a lot of work, because there are pitfalls in budget that sadly we can't help. And I'm willing to work with everybody to make lives better for victims and witnesses. Thank you.
Questions? Delegate Conway.
Mr. Chairman, thank you for coming in to testify. So if we move the bill on the favorable, you'd be okay, or you have to have some amendments?
So the problem with this bill, it conflicts with the guidelines we presently have, and I anticipate what they're currently redoing, it conflicts with it, and I think it could prevent funding from happening.
So that's...
Yes and no. Amend the bill, make it applicable to the rules. I'm
As
all for it.
As it stands, it's a no.
It could be a yes, but it's going to run into unintended and intended consequences is the problem. But I'm happy to try to help them get as much money as they can. I'm all for it.
Thank you very much.
Further questions? Seeing none, thank you very much. Now that concludes the testimony on House Bill 974. We're going now to Delegate Weibel on House Bill 845. Delegate Weibel, David Foltz. Bob Enton is here, favorable with amendments, but we can, I don't know whether you, what I'll do is I'll hear from the delegate. Is David Foltz here or no?
Mr. Foltz was here at 10 a.m., but he left and went back to Washington.
I understand. All right, so go ahead. We'll hear from you for 3 minutes, then we'll hear from Mr. Enton, Mr. Costelli.
Thank you, Chairman Clippinger and honorable members of the Judiciary Committee. I'm Delegate Weibel. Please present House Bill 845, Real Property Recordation of Instrument with False Information. I actually was approached by Mr. Foltz, who had recently fought a court battle defending his title to his property in Washington County. Someone else had prepared a deed recording his interest in real property over the deed of the rightful owner. Mr. Foltz went on to explain that once he discovered the false recording, he spent $80,000 in court costs and attorney's fees successfully defending the title to his real property. House Bill 845 simply states that a person may not falsely record a deed or other instrument that the person knows contains false information. Doing so would result in a misdemeanor conviction and a fine not to exceed $500. What House Bill 845 also does is allow the court to award attorney's fees to either party in defense of a claim in regards to a violation of this code section. I have asked for 2 amendments. The first is simple. It removes the language "or has reason to know" on page 2, line 21, so it would read that a person may not record a deed or other instrument that the person knows contains false information, including information related to ownership of the property. With that amendment, Bob Enton of the Bankers Association tells me that he is fine with the bill. The second amendment would remove Washington County from Section 3-104 of the Maryland Annotated Code, which lists Washington County as an exception to certain requirements before recording a deed. We believe that this would negate the recording of any such straw deeds in the future. So as amended, the bill would accomplish three things. It removes Washington County from exceptions for recording deeds. It prohibits and creates a misdemeanor conviction for someone who records such a deed, and it allows for recovery of reasonable attorney's fees. It's also my understanding that the Maryland Realtors, and I believe Bill Costelli's here, are also okay with the bill with the First Amendment. And again, as I stated, Mr. Folt sends his apologies, but he had to head back to Washington County. That concludes my testimony, and I ask for a favorable report on House Bill 845.
Questions for the delegate? Seeing none, thank you very much. We'll hear from Mr. Costelli. Mr. Ensign, please. Or I saw Mr. Ensign, but not anymore maybe, but see Mr. Costelli, who's at least on my list, is signed up as unfavorable. We'll go from there.
Yes, thank you, Mr. Chair. Bill Castelli on behalf of the Maryland Realtors, and we were originally signed up as favorable, but as Delegate Weigel said, and we want to thank Delegate Weigel, with that First Amendment, removing the language or as reason to know, that would address the realtor concerns. And Mr. Enton did have to leave, but that would address the bankers' concerns as well.
Questions? Seeing none, thank you very much. That concludes the testimony for House Bill 845. We're going now to Dorchester County. Delegate Hutchinson. And Delegate, we'll hear from you. Go ahead for 3 minutes, please.
Thank you. Good evening, Mr. Chairman, members of the Judiciary Committee. This is my first time at this committee, and I'm excited to be here. For the record, I am Delegate Tom Hutchinson, Chair of the Dorchester County Delegation. I'm here to present House Bill 194. I know it's late, so here's what I got to do in the next couple minutes. This bill is to legislatively approve Cambridge Waterfront Development, also known as CWDI, as an instrumentality of government to become a member of the Local Government Insurance Trust. And why I'm spelling it out that way is that last year this bill was presented. It passed the Senate. It did not pass through this committee. And when I spoke to Speaker Pro Tem, who was the House sponsor last year, she said, I do think there was some confusion as to what CWDI is and what the Local Government Insurance Trust, also known as LEGIT, is. So that's what we're here to do. So, CWDI is a quasi-government nonprofit economic development corporation that was formed between the City of Cambridge and Dorchester County, two local governments. Its sole purpose is to develop a 33-acre property that was created by a land transfer between the state of Maryland to the City of Cambridge through the purchase of state property, which was where the Dorchester General Hospital was, part of the University of Maryland Medical System, and annexing existing property also known as Salewinds Park, which were covered under LEGIT. Today, the entire property is known as Cambridge Harbor, and it's a tremendous economic project that has taken over 20 years for us to get to this point. When you drive over the Choptank River Bridge, you look to the right, there used to be a hospital, used to be a big green field. That green field's going to come back, but also a wonderful place to have fun in Dorchester County is going to appear on our beautiful waterfront. You know, it's not uncommon for quasi-government or instruments of government to join LEGIT. Today, there's over 30 non-government entities that have joined LEGIT. I want to emphasize that CWDI is a nonprofit organization. It is not a big developer. Nobody is making money here. Nobody is padding their pockets here. It was developed because we had the City of Cambridge and Dorchester County, who sometimes can't get along with each other, an idea to say, if we create CWDI, we know this project's actually going to get done. It has board members that are appointed by the City of Cambridge, Dorchester County, and the governor of the state of Maryland. So right now, we're working on the infrastructure, we're getting the roads laid out, and then all that property will be sold to the real private developers who will have to pay for their real property insurance and their liability insurance and take that over. When it's all said and done, we're going to have a beautiful park, waterfront property, a beach that will be maintained by CWDI and has every right to be covered by LEGIT. So I ask for a favorable vote on House Bill 194.
Yeah, thank you, Mr. Chairman, members of the committee. My name is Chip McLeod. I'm an attorney from Chestertown, and I serve as general counsel to Cambridge Waterfront Development, Inc. I also, in my practice, represent a number of local governments and have a lot of experience with LEGIT. And LEGIT, background, Local Government Insurance Trust is often referred to as LEGIT, L-G-I-T. If you've attended any MML or MACO conference, you've seen LEGIT. LEGIT is a pool for local governments that was formed out of the liability insurance crisis in the 80s. And I'm going to date myself. At that time, I was an associate director at the Maryland Association of Counties when MACO and MML were collaborating to form the Local Government Insurance Trust in response to the liability insurance crisis, when it was very hard for local governments to insure beaches and all that. So fast forward to today, LEGIT is a very successful organization. Many local governments in Maryland belong to LEGIT, as did Cambridge and Dorchester County, and insured a lot of the property we're talking about. So as the delegate mentioned, City of Cambridge and Dorchester County, through an MOU, formed this Economic Development Corporation, which is tax exempt through the IRS. Its mission is to help redevelop the property, sell it back off, get it on the tax rolls. What will remain out of about 35 acres is about 20%, or 7 acres, that's promenade and park. And CWDI will be responsible for ensuring all that public space when all is said and done, after all the redevelopment. But before then, CWDI is now responsible for about 35 acres, given in part by the city. Some came from University of Maryland Medical System. So they're now responsible for all this. Their insurance premiums are a little bit higher. They want to be a member of LEGIT. And here's the key issue. This is why we have to come to the General Assembly. LEGIT's scopes of coverage, their insurance contracts with local governments, if I may, Mr. Chairman? Yes. Say that we will insure your instrumentalities, your libraries, your transit authorities, your humane societies, if they are covered under the Local Government Tort Claims Act. Because LEGIT doesn't want to take on more exposure than it was set up to take on, which is local government liability, and now these instrumentalities. So we're only here because CWDI wants to be a member of LEGIT to get that kind of, that coverage and that service, much like the City of Cambridge and Dorchester County enjoyed, but we can't unless we are included under the Local Government Tort Claims Act. And as the delegate mentioned, if you look at that list, there's a number of very similar organizations from other counties.
All right, thank you very much. We'll hear questions now. Delegate Schmidt.
Just can't help myself. Are you too legit to quit?
I can tell it's getting late here, too.
In all honesty, I do have a legitimate question. CWDI, you had mentioned, as a non-profit, correct?
That's correct.
Now, how is that funded currently?
Well, actually, glad you asked that, Delegate. Right now, about $8 million directly from the state of Maryland through primarily a lot from DHCD. About $2.4 million from the federal government through an economic development agency. Money from the state and the city through the ARPA program. And then directly from the city and directly from the county. This has been all paid for by government.
And how long has that been going on for?
Well, the entity was formed about 2 or 3 years ago.
Okay.
So the city and the county have really been covering their operational costs. Now that they have all the property under their control, they're in full mode of trying to get developers to come, and they're heavily marketing all this property to find developers.
Okay. Thank you.
Yes.
Any further questions? Seeing none, thank you both very much. One person in opposition, Mr. Plaxton, please.
Thank you all.
Thank you.
Good evening, Mr. Chair, members of the committee. I'm Bruce Plaxton from the Maryland Association for Justice. I also run a law firm that represents injured people throughout the state of Maryland. When you hear the proponents say they want to join LEGIT, it's not like joining a country club that they want to be a member of. Joining LEGIT or being redefined as a local government means that the people injured on this property will only get $400,000, not full compensation. It also means that if a mass event happens, like a boating accident or a building collapse, everyone combined will only get $800,000. What you're doing is you're saving the city of Cambridge and the county of Dorchester a few pennies on a multi-million-dollar complex. You heard that it's 35 acres. You can Google it. It has 239 apartments, a hotel, retail stores, bars, dining, docks, boat ramp, canoes, kayak rentals, parking lots, mixed-use housing, playgrounds, a promenade, etc. Any of your constituents that go there could get injured, and they will have their rights limited in order to save. And it's not like this entity cannot buy insurance. They have been buying insurance for years, just not through Legit. It's not exciting to buy the insurance through Legit. What's exciting is to limit your recovery to only, limit your exposure to only $400,000. And the fiscal note is interesting because they were reached out to several times by the fiscal analyst, and Dorchester County refused to give them numbers on the fiscal note. So they guessed from last year, and last year's fiscal note was a total of $10,000 on a multi-million-dollar project, 35 acres. This bill, the whole reason we're here this late at night, is to save the county and the city $10,000 and give away the rights of your constituents. So we urge an unfavorable report.
Thank you, Mr. Chair. Thanks for coming in. I'm just trying to compare this situation to the other types of developments we have around the state. So, like, for example, Ocean City, the beachfront there, is that in Legit, or is that protected by the Tort Claims Act?
I have to go and look. There's a list of 29. They said it was over 30. I think this would be number 30. There are things like years ago, this legislature, in my opinion, made a mistake and brought in Lexington Market as a quasi-governmental unit of Baltimore City, things like that. I'm not certain that continuing the expansion of these types of quasi-governmental units is useful. I don't know the answer about Ocean City.
Yeah, because I'm just trying to figure out, because obviously this, a beach that's publicly managed or even privately managed is one thing, but apartment buildings, obviously, that's maybe a little uncomfortable. But I assume the people that live in the apartment buildings are also going to be restricted in the amount of compensation they're eligible for if they're injured in their own apartment building?
If the claim is against CWDI, they will be limited, yeah. So,
Okay.
And you heard they're going to build roads, they're going to build, overpasses, they're going to build a promenade and sell it back to local developers. But if something they built ends up collapsing or causing harm years from now, people will be limited to $400,000 and not be able to get their full rights.
Okay, I think I get it better. So then if a private developer then builds an apartment building on what they have done, their portion is under the Tort Claims Act, but the actual private development infrastructure that they build would not be.
That's how I understand.
Okay, thank you very much.
Thank you, Mr. Chairman. Thank you for coming in to testify. So you said something about the Lexington Market, and they are under the torts claim cap now?
At the request of Baltimore City years ago, Lexington Market, in order to develop Lexington Market, was brought under the Local Government Tort Claims Act.
Okay.
If you look at it, there are several there that, in our opinion, in my opinion, don't belong already. I'm not sure that you continue to give private entities or private developments. This is nothing more, in my mind, than a 35-acre land development, why this would be covered by the Local Government Tort Claims Act.
So how much insurance do you think they should have on this property?
Whatever they're buying, I mean, like Prince George's County requires every vendor they do business with to carry $2 million worth of insurance. I don't know what other counties do. I don't know the right amount to be properly insured, but it's not $400,000. You shouldn't limit people to $400,000 to save $5,000, save a total of $10,000. They can buy millions of dollars worth of insurance, and they're already covered. The policy note is wrong. The policy note says that there'll be less expenditures and the risk of Dorchester and the city of Cambridge will be diminished. Their exposure won't be diminished at all. They already have, Dorchester and Cambridge are already covered under the Local Government Tort Claims Act.
Okay.
So when you read the fiscal note, and it says, under local expenditures, Expenditures for Dorchester County and the city of Cambridge decreased due to reduced costs for insurance coverage. That's true. That's about $10,000. At least that was the guess 2 years ago. It says, and reduced future exposure to liability. That part is inaccurate in your policy note because the city of Cambridge and Dorchester County already are limited under the Local Government Tort Claims Act to $400,000. So anything a city employee has done on that waterfront and makes the city or the county responsible is already covered under the Local Government Tort Claims Act.
Okay, thank you very much. The reason why I asked you the question is I raised the torts claim caps at one time, and one of my colleagues texted me and said, "Don't ask about Lexington Market. That's in Baltimore." So it's okay.
I volunteered it.
I understand.
You know,
I'm just saying that to rub it in. You know?
Yeah, no, it's out there, and I appreciate.
They know who I'm talking about.
Yeah, no,
That's too legit to quit. Right.
A few years ago, we did raise the Local Government Tort Claims Act. It was 100, 200, and 200, 400 for the state for a long time, and that's really low. Yeah.
Further questions? Delegate Tomlinson?
I mean, I'm looking at the testimony, and they have pictures of the property and what the property, what it will look like. Hopefully, when it's done.
Quite a project.
This organization, they're not going to own, the individual buildings. Won't it be the property owners? Like you mentioned a building collapsing. Wouldn't the owner of that building, wouldn't they be liable? Not the organization, whatever it is, CWDI.
They're gonna, I don't know, what I heard today was the same thing you all heard, which was their plan is to sell off part of it. But presumably they're still going to be responsible for the promenade that they build, the parks, maybe the Maritime Museum, which I've seen in one of the plans, if it stays under county control. I don't know what parts of the project are going to stay under CWDI. So some of it presumably is still going to carry on and still be subject to these. And obviously anything they do while developing the project and they make a mistake and someone gets hurt because the promenade falls in the water, or the boat docks that they built, the yacht basin that I see in some of the plans, the maintenance, I don't know, the amphitheater, if that gets built by them, not private developers, yeah, I assume that's going to carry on.
Okay.
I just, this is to save them a few $1,000s a year.
Thank you, Mr. Chair. I think you answered it, but I used to, in my younger days, do the Blackwater Triathlon right in Cambridge, and you went underneath the bridge. When I did it, you went over, and you actually, where they're looking on building a pier, I guess, out, that's where you would get out of the water. If you could actually, I've done triathlons where you actually climb out by ladder out onto the pier. If that pier was not built right, and it crushed a triathlete and killed him, that would be covered under Dorchester. That wouldn't be under the private developer because that was built by Dorchester. Is that correct?
That's the way I understand it, yeah. And if it killed 10 people, they'd have to split $800,000.
Thank you.
Any further questions? Seeing none, that concludes the testimony on House Bill 194. Now we're on House Bill 1143. Delegate Moon, the last bill. Rebecca Snyder, come on up. Kiana Johnson on virtually? No? Okay. Jason Billingsley? No. Going to hear from the Vice Chair, and then Rebecca Snyder, and we'll go from there.
Touched it. All right, good evening, colleagues. House Bill 1143 is a bill that simply maintains current practice with respect to the public having access to court audio transcripts of criminal proceedings and being able to rebroadcast them. You may have heard about this because the federal courts said in the case of Soderbergh v. Carrion this past December that the Maryland courts were wrong to try and prevent members of the press from rebroadcasting audio transcripts that they had been given from the court. So that's what happened, and the court responded to this. Courts responded to this by floating a proposal that said, well, if that's true, then maybe the real problem is we need to actually take away the public's access to the audio transcripts altogether. There was an outcry, and so they said, oh, never mind, we're going back to the drawing board. Maybe the legislature has something to say about this. I think we do. That's why this bill is here, to say, no, you have to maintain this access. And of course, this was requested by the good press advocates for the journalists who are here with us today. The last thing I'll say about this is I don't want us to be totally in the clear here, because the Assembly itself only recently made changes very much like this. It used to be the case that if you wanted to see how this committee voted on bills, you had to come physically in person and pull down the files. Only very recently those were put up online so that everybody could have access to them. And the same is now true with being able to see our pretty or not pretty faces on the floor and in committee as we talk about bills. So I think it's fine for the judges to deal with the same. Thank you.
Thank you, committee, and thank you for holding on to be for this last bill. So for the record, my name is Rebecca Snyder. I'm the Executive Director of the Maryland-Delaware D.C. Press Association, and we thank Delegate Moon, Vice Chair Moon, for bringing this bill. He's shared sort of why we felt we needed to bring this bill, but I wanted to address two issues. Reporters and news media in general request and receive the audio, copies of the audio recordings of criminal proceedings now. So you can, in most jurisdictions, you can email the courthouse staff, and they sometimes for a fee or whatnot, they will provide that audio recording. Reporters use that to increase the accuracy of their reporting, to fact check. You know, if you think about going into an open courtroom or not having a record, you can't possibly remember all the details of everything, even with fabulous notes. So we really do rely on that to increase coverage. It also allows reporters to be in more places at once. So the second piece is the idea that once recordings are out in the public, they'll be used they'll be weaponized, and victims will be intimidated, and witnesses will be intimidated. Victims will be further victimized. The judges already have a significant amount of discretion to shield open court proceedings and the recordings. This does not take away at all from that discretion. In fact, they can do what they need to. And so we feel like, in addition, there has been no record of witness intimidation through recorded audio. So we just feel like this is a bill that is needed now to make sure that the public does have access to these recorded audio proceedings, and we request a favorable report. Thank you.
Yeah, real quick, if any of my colleagues had the judiciary raising separation of powers issues on their bingo card, please mark it off. Would you like to comment on why this is not an issue of separation of powers, Mr. Vice Chair?
Well, I think in this instance, the federal courts are actually intervening to say something's amiss with what our courts are attempting to do. I think that invites this discussion. I think the Rules Committee themselves punting on this, and I do understand they're taking this matter up again, and some have suggested we should hold off to see what they do. But I'm hoping that what this means is there won't be a separation of powers issue, because maybe they come to their senses.
Oh, goody. Looking forward to that day.
Thank you, Mr. Chair. I'm just curious on, Rebecca, is there a law or a policy against, like, taking recordings and editing them to misconstrue and then publish what happened in a court? Is that a concern that the courts have? Like, you could take it, you could edit it out and make it appear as if, you know, a judge was not doing things appropriately by changing the I'm not suggesting that the Washington Post would ever do that, but I am suggesting that there are people out there who might want to make the courts not look good and therefore take these things, publish them in a way that is
I
incorrect.
can't speak for the courts specifically. I know that's not something, news media does not try and, edit down to do like deep fake videos and things like that. So I guess it's always a concern, but that can happen, that can happen in an open courtroom when someone says, look, this is what the judge said, and you don't even have audio or a recording to back it up.
Right, but if you have the judge's voice, but it's well edited, so it seems as if he's saying something that, or she's saying something that they're not actually saying or insinuating.
I feel like, wouldn't that come under maybe like a libel or something? Like, I feel like I can't really speak to it specifically.
Okay. All right.
You can inaccurately meme a judge without the audio of the judge. I would also suggest, people do it to me all the time. The 2A people love to put me on YouTube videos, so.
Fair enough.
Questions for the panel? Seeing none, or seeing no further questions.
Oh,
Okay,
Dylan.
for the panel, quickly, that ends the hearing on House Bill 1143. It ends the bill hearings for today. We will start a voting session at 7:40 p.m. Thank you.